Good evening and welcome to the June 20th, 2022 Rental Housing Committee meeting. This meeting will be conducted in accordance with California Government Code 54953E as authorized by a resolution of the Rental Housing Committee. Please contact mvrent at mountainview.gov to obtain a copy of the applicable resolution. All members of the Rental Housing Committee will participate in the meeting by video conference with no physical meeting location. Members of the public wishing to observe the meeting live may do so at mountainview.legistar.com, on YouTube at mountainview.gov/YouTube, and on Comcast Channel 26. As noted on the meeting agenda, members of the public may provide oral public comments during the public comment period for an item by signing up at mountainview.gov/meeting and entering webinar ID 937-7306-8363, or by phone by dialing 669-900-9128 and entering webinar ID 937-7306-8363. Any emails received by 5 p.m. today were forwarded to the Rental Housing Committee. Emails received after 5 p.m. will not be read during the meeting, but will be entered into the record for the meeting. The Rental Housing Committee will enter a separate closed session Zoom meeting to discuss existing litigation regarding Redwood Villa Inc. versus City of Mountain View and Mountain View Rental Housing Committee, Santa Clara County Superior Court case number 18 CV 322991. The committee will reconvene on this public Zoom meeting once the closed session has ended. Legal counsel will report any updates from the closed session during the agenda item 12. Now, before we do that, would any member of the public on the line like to provide comment on the closed session agenda item? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. And I see one hand. Adrian, do you want to join us and unmute?
Oh, there we go. Can you hear me now? Mm-hmm. Thank you very much. My name is Adrian Ferrari, and I help manage 2 multifamily complexes in Mountain View. The proposed amendment to the definition of base rent in Chapter 2 of the CSFRAs is contrary to the CSFRA's existing definition of the word rent. Rent is defined as having 2 component parts: the periodic payments by a tenant and the non-monetary consideration. The periodic payments is the part of the definition of the word rent that's relevant here. If the tenant receives a 1-month move-in special on a 12-month lease and then pays the full contract rent for the remaining 11 months, the amount of the tenant's periodic payments is what the tenant pays for each of the last 11 months. To reduce that amount to 1/20th of a concession is to redefine what the word rent means to something other than the tenant's periodic payments. The Rental Housing Committee, however, is bound by the substantive terms of the CSFRA and cannot use the regulations to introduce substantive changes to the meaning of the words in the CSFRA. Regulations that change the substantive meaning of the implementing law are void, and nowhere does the CSFRA suggest that a periodic payment should mean anything other than the amount that the tenant pays periodically. This issue highlights a key provision with the proposed amendment. It treats all types of concessions in the same way, but a 1-month move-in special is different than a concession that is amortized over the term of a lease. In the case of an amortized concession, the tenant's periodic payment could actually be the amount of rent less the concession. The same is not true for an upfront concession, where the tenant and a landlord have structured it as a one-time discount. Any proposal to address the impact of concessions on the annual rent increases must differentiate between upfront concessions and amortized concessions. Lumping them together, as the current proposal does, introduces a conflict with the definition of the word rent, which again is tied to the amount the tenant pays periodically. My colleagues have raised this concern directly with program staff, but the June 20th memo respectfully does not address this subject. It analyzes the definition of base rent in the CSFRA, but not the definition of the word rent simply itself. But since the definition of base rent is actually based in part on the definition of rent, it's necessary to analyze that definition as well. The Rental Housing Committee should not move forward on this incomplete record. Instead, I would respectfully request that the program staff withdraw the proposed amendment to Chapter 2 and replace it with a more considered alternative that maybe distinguishes.
Adrian, thank you for your comments. I believe you were commenting on item 9.1. We are currently doing public comment on the closed session regarding the litigation between Redwood Villa Inc. and City of Mountain View and Mountain View Rental Housing Committee. Does anyone else have comments on the litigation and closed session before we go into the closed session? Okay, seeing none, committee, let's move to the closed session. Public, we will be back shortly. I probably will be a little bit longer than last meeting in terms of the closed session, but we will return to this Zoom once we're done with the closed session. Thank you. Looks like almost everyone is back. Alrighty, in interest of time, good evening and welcome to the June 20th, 2022 Rental Housing Committee meeting open session. The meeting is called to order at 7:32 p.m. Now I will proceed with roll call.
Did you want us to help you with that, Chair?
That would be awesome.
Perfect.
Chair Hain-Livesey.
Present.
Vice Chair Ramos.
Present.
Committee Member Rosas. Committee Member Almond.
Aye.
Committee Member Pardo de Zella.
Present.
It looks like we also have Committee Member Grunwald who just joined us.
Yes, present.
And we're just waiting for Committee Member Rosas to join. She was with you in the closest.
Yeah,
We'll
she was having some internet.
Okay.
There she is.
Committee Member Rosas, are you with us?
Yes, I am. And sorry for being the last one again.
No
problem. Thank you.
Excellent. We will now move to agenda item 5, the consent calendar. These items will be approved by one motion unless any member of the committee wishes to remove an item for discussion. The purpose of the consent calendar is for the committee to efficiently and quickly consider routine or administrative business items in one motion. Although committee members may remove items, it is generally not intended for the committee to have a lengthy substance discussion on the consent calendar items. Would any member of the committee like to pull an item? Okay. Seeing none, would any member of the public on the line like to provide comment on the consent calendar item? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Okay. I'm seeing none. So now I'm going to bring the item back to the committee for action. A motion to approve the consent calendar should include the reading of titles of the agenda items or the resolutions attached to the agenda items 5.1 and 5.2. A motion to approve should include reading the following items. For a 5.1, approve the minutes for May 23rd, 2022 RHC meetings. And for 5.2, approve a resolution making findings authorizing continued remote teleconference meetings of the Rental Housing Committee pursuant to the Brown Act provisions as amended by Assembly Bill number 361. And I see a hand, Vice Chair Ramos.
Thank you, Chair. I move to approve the minutes to the RHC meeting on May 23rd, 2022, and to adopt a resolution to continue virtual meetings pursuant to Brown Act provisions as amended by AB 361.
I second it.
Excellent. Let's do the roll call vote.
Committee Member Pardo de Zella.
I don't think we got your vote, committee member. You're still muted, sorry.
No? Can you hear me okay? No.
Yep, thank you.
Committee Member Almond.
Yes.
Committee Member Rosas.
Yes.
Vice Chair Ramos,
Yes.
Chair Hain Livesey.
Yes.
Motion passes 4 votes to 1.
Okay, excellent. Moving right along. We will now open the meeting for oral communication from the public. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public on the line like to provide comment on non-agenda items? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. And I see one hand from Stephen Goldstein. Let's advance Stephen into a speaker mode.
Thank you very much for your time. Can you hear me?
We can hear you.
Okay. Please understand this. Once any agency of any state or county makes a declaration regarding the property of value, and it's significantly less than the original value that was signed on a rental agreement. For example, a history of one building was once currently a value of $5 million, but in the last 2 years, the property owner had the property reappraised to only $3.8 million. With regards to property taxes, the local tax assessors are responsible for calculating and assessed value of properties in their municipality. While some aspects of the calculation may vary, they generally take the fair market value of the property and multiply it by an assessment ratio to determine how much your taxes are. Since the rental contracts are based on the value of the property as signed, in this case may be as far back as 2016, and the value has been changed, that would in effect define that the landlord's activities had breached the rental contract by covertly declaring the value officially with any agency regarding the value, which is not the value that the original contract was signed on. This becomes a breach of contract, and in effect, one can argue the entire rent collected under those conditions is not lawful. This is what's happening here in Mountain View. The idea that a landlord is in breaching contract when they covertly, intentionally reduce the value of their own property for tax benefit purposes. Since the CSFRA clearly states that a reduction of value is to be a default reduction in housing services. Because the rental value has been reduced by the landlord, there is a required reduction in rents for any rental controlled unit under those circumstances. Specifically, with regards to David Avenue, 184 Center Street, he originally bought the property for $5 million. The SEC tax appraisal recently has established that the land is worth $2.4 million and that the original building was worth $2.5 million. However, the latest report indicates now that the building is only worth $1.45 million. That is in effect a loss of building value of 45%. That in effect also basically declares that since the value has actually gone down, that means the services have been by default not been provided. All you need to do is look at the Santa Clara County website to look at it. The fact is, this should require a regulation that says that any property tax reduction requires a rental reduction proportionately. Thank you.
Thank you, Stephen. And now we'll advance Scott A.
Can you hear me okay?
We can hear you.
Thank you. I'd like to bring up a general principle that appears lost in some of the weeds here. The CSFRA has a market safety provision, section 1718, which is titled Decontrol. It reads, if the average annual vacancy rate in controlled rental units exceeds 5%, the committee is empowered in order to achieve the objectives of this article to suspend the provisions of this article. If the committee finds that the average annual vacancy rate has thereafter fallen below 5%, the provisions of this article shall be reimposed. This has not been factored and fully acted upon by the RHC. Temporary decontrol was a central and essential balancing factor that voters approved. It was clearly designed for circumstances of widespread vacancy and falling rents, and that using those suppressed rents as a basis in CSFRA would need to be suspended. Rather than the whole, one way to do this is the months where vacancy exceeded 5% during the past 2 years need to be removed from being factored into base rent calculations, rollback revisions, and rent concession discussions. Temporary incentives should not be locked in during that suppressed rent high vacancy time period. That was the purpose and intent of this limiting language. If the vacancy is high, there is an issue in the market. It is not balanced, and rents are forced into being uncharacteristically lowered or heavy incentives and concessions provided, such that the base rent would not reflect a balanced market, and landlords would be permanently punished for 10 to 20 years if such were made permanent. To the extent the landlords identified clearly with tenants that these were not permanent rent reductions, they are to be commended. When listed as temporary limited concessions or credits, tenants knew clearly that these were one-time temporary assistance or incentives. Now, I understand their natural motivations to now lock that in. In cases where the landlords were vague, the confusion is understandable and should be remedied case by case with clarity provided by the RHC for future. However, prior to voting on or implementing any changes or clarifications now proposed, in order to not selectively enforce, but be balanced and aligned with this voter provision, the RHC should undertake a full analysis of the vacancy rate for covered units by month for the past 2 years. Then, in fairness, RHC should discuss and implement Section 1718 first, excluding those months of suppressed rents and heightened concessions from base rent calculations. This will also help define and set parameters to any retroactive resets. This aligns with voters' intent and objectives, and I ask you to direct staff and place this on the next RHC meeting for public discussion and action, and not take any action on any proposals before fully doing so. Thank you. We appreciate your service.
Thank you very much, Scott. And now if we can advance Anna Marie M. into the speaker area.
Hello, thank you so much. Ableism is real, and taking away virtual or hybrid meetings is violating the rights of disabled people.
Anna Marie, we just lost you.
Oh, can you hear me now?
Yes.
Okay, perfect. I don't know where I cut out, but basically I was just saying ableism is real. Taking away virtual or hybrid meetings is violating the rights of a large group of various people, low income, people with mobility issues, immunocompromised, the list can go on, to equally participate in these community meetings. Are these meetings not meant for all residents of Mountain View? I urge this committee to keep virtual or implement hybrid meetings to keep them safe and accessible for all. Thank you very much.
Thank you, Anna Marie. Committee Member Almond, do you have a comment?
It just seems like a couple of the public comment really had to do with agenda items, and I thought that this is supposed to be non-agenda items.
It is still a non-agenda items. This is still just open public comment. Okay, but with seeing no one else to speak, we will now transition into agenda item 9.1, amendment to chapter 2, definitions of the CSFRA regulations, amendment to chapter 4, petition process of the CSFRA regulations, amendment to chapter 2, definitions of the MHRSO regulations, amendment to chapter 5, petition process of the MHRSO regulations. We will begin with a presentation from staff.
Yes, good evening. I will be making the presentation tonight. So what you have before you is Regulation amendments, as the chair just read, to chapters 2 and 4 of the CSFRA regulations and chapter 2 and 5 of the MHRSO regulations, designed to clarify the calculation of base rent where a rent concession was provided, and to establish a statute of limitations on the recovery of back rent where a petition was filed on the basis of an unlawful rent related to concessions. Next slide, please. So this item is before you, and we have discussed it before, but it is before you because RHC staff was receiving questions from both landlords and tenants about how to determine base rent when there was a concession, either in the form of a discount, a reduction in rent, or a 3 months rent, or a couple months rent, whatever it is, when that was offered during the initial term of the tenancy. Next slide. So this item first came before you on March 28th. At that point, before that meeting started, the RHC received quite a bit of correspondence on the item. And as a result of that correspondence, the RHC elected to postpone the item in order to obtain more input from the stakeholders. So stakeholder meetings were held on April 28th. There were 2 meetings, one with landlords and one primarily for landlords, one primarily for tenants. And then last month on May 23rd, you held a study session discussing this item. So at your May 23rd meeting, you heard from staff about the purposes of the CSFRA and the MHRSO. We also discussed the authority for adopting regulations, the definition of base rent in each of those regulatory schemes. You also received a summary of the stakeholder meetings and extensive public comments. And we also went over what other jurisdictions with rent stabilization have adopted with regard to this matter and the intent of adopting regulations to address the issue. So it was a pretty lively conversation, and staff did hear what everyone said and tried to take that into account in bringing back the regulations. Next slide. So at the end of your May 23rd meeting, the chair called for a series of straw votes. So the first question was, does the calculation of base rent require clarification to address concessions? And the response to that was 5 yeses and 1 no. And for purposes of these straw votes, the alternate did participate. So the next question is, should the proposed regulations address the issue of retroactive application? And that one, there were 4 yeses, 1 no, and 1 abstention. The third question was, should the calculation exclude any rent that the tenant fails to pay or withholds in violation of the agreement? On that one, all 6 of the RHC members and alternate were in agreement. And then the final question that was put to the RHC was, should all types of concessions be treated the same when calculating base rent? This arose out of a conversation about maybe a first month free should be treated differently than a rent reduction for the entire initial term. That one tied 3-3. The alternate's vote was on the no side. So staff, in looking at that, took that to be all concessions should be treated in the same way when calculating base rent. Next slide. So what you have before you are substantially identical regulations for both the CSFRA and the MHRSO. What they include is the following. So these regulations only address base rent with regard to tenancies under the CSFRA that commenced after October 19th, 2015, and the MHRSO for tenancies that commenced after March 16th, 2021. And the reason for that is that each of the CSFRA and the MHRSO have very specific definitions for tenancies that commenced before those set dates. And essentially what those definitions say is the base rent is the rent in effect on the date, on that date. So it is a different terminology that impacts tenancies that were in place on those dates. So the regulations also provide a clarification on how base rent is to be determined when a concession is granted. And essentially the concession would be treated as, it would be calculated as part of the base rent. And it provides some examples of what concessions are, but it is not limited. There may be other types of concessions that would be covered. But these were the most common that we have come across, which are 1 or more free months of rent or a dollar or percentage reduction in rent provided over the course of the initial tenancy. The regulations also make clear that the tenant's failure to pay rent, or if the tenant gets a rent reduction as a result of a habitability petition or a decrease in housing services, will not impact base rent. So this was one of the issues that came up at your meeting in May and at the stakeholder meetings of how do you address the fact that maybe tenants don't pay the rent, and particularly during COVID. We know that there was substantial periods of time when tenants could not pay their rent, that should not really impact the base rent, that would penalize landlords. So the regulation makes it clear that it is the rent that was demanded and paid. So it will not allow tenants to use non-payment as a basis to change their base rent. And then finally, the regulations set the initial term of the tenancy. If the initial term of the tenancy is less than 12 months, it will be the initial term of the tenancy. If it's a month-to-month rental agreement, then the initial term will be considered 12 months. And if the rental agreement is for longer than 12 months, then the initial term will also be considered 12 months. So next slide. So just by way of calculation and sort of examples of how this would work. In our first example, a tenant would sign a 12-month lease with a contract rent of $1,000 a month. But as part of the lease, the tenant would be given 2 months free rent during that 12-month period. So the base rent for that tenant would be $833.33, which is 10 months of rent at $1,000 divided by 12, which is the initial term of the tenancy. So another example is the tenant signs a 12-month lease with a contract rent of $1,000 a month, but the landlord agrees that the tenant can pay only $750 a month during that time period, or only has to pay $750 a month for those first 12 months, in which case the base rent would be $750 because that's what was demanded. So next slide. So on the initial term of the tenancy, if the tenant signs a 6-month lease at $1,000 a month and there's 1 month of free rent, so the base rent would be determined over that 6-month term. So once again, we would have $833 as the base rent because the tenant in that example would pay 5 months at $1,000 over a 6-month term. The other example is, let's say the tenant signs a 15-month lease with a contract rent of $1,000 a month, and there are 2 months of free rent during the first 12 months of the lease. In that example, we would use 12 months as the initial term of the tenancy. And once again, the rent would be $833.33 because the tenant would have paid 10 months of rent at $1,000 for a 12-month term. Next slide. So, and then also in response to some of the comments that we received last month at the stakeholder meeting, we are also proposing amendments to Chapter 4 of the CSFRA regulations and Chapter 5 of the Mhrso to put a limit on the amount of overpaid rent that tenants could recover. And this was a concern that we heard, that people were concerned that tenants could go back to the beginning of the CSFRA in particular, since it's been around longer, and potentially recover back rent for the last 5 or 6 years. So what we have put into the regulations is that a tenant would be entitled to a rollback to whatever the lawful rent would be. But if a tenant filed a petition, that tenant would only be entitled to a refund of overpaid rent for the 12-month period prior to the date of the petition. So it would limit the recovery to 1 year, as opposed to the applicable statute of limitations if we say nothing, which would presumably be 3 years, as that's the statute of limitations under state law for statutes. For tenancies that commenced after September 1st of 2022, the regulation is slightly different and would essentially say that the tenant would be entitled to a rollback and a refund of any overpaid rent subject to any applicable statute of limitations. And the distinction is made because one of the concerns that we also heard was landlords didn't have knowledge of the potential of how base rent actually worked. So presumably after September 1st, 2022, for any tenancy that commenced, this regulation clarifies and they can conduct their business appropriately. We also are proposing that an additional regulation be added that would make it clear that a former tenant can only file a petition for an unlawful rent related to a concession within 6 months after vacating, so that former tenants couldn't come back many years later and try to recover. Next slide. So just by way of example, in this example, we have a tenant who signed a 12-month lease in June of 2019, and with a contract rent of $1,000 a month with a 25% discount. So this is similar to our prior example. The base rent would be $750. The tenant then starts paying the full $1,000 on June 1st of 2020, so in the 13th month, and continues to pay that amount. And for simplicity, we said the property owner does not impose any additional rent increases. So then the tenant waits a couple years, files a petition for unlawful rent based on the concession, and the rent is rolled back to $750 based on that petition. The tenant would only be able to recover the last 12 months of overpaid rent. So in this example, $250. So the recovery would be limited to $3,000 as opposed to potential $6,000. And just to note, under the CSFRA, once the tenant did recover the overpaid rent, the landlord would be eligible to take any of the annual general adjustments. So those are not lost as a result of the overpayment of rent. They just are deferred. So next slide. So, and one of the other questions that we received at the May meeting was the concern about trouble damages potentially. The CSFRA does allow tenants to bring civil suit against their landlord, and there is the option of trouble damages. Those trouble damages can only be awarded if the landlord acted willfully and with oppression, fraud, or malice. So that is a pretty high standard. Trouble damages are considered a penal damage, and they are governed by a 1-year statute of limitations. So this would be a state law issue. We didn't address this in the regulations because this is governed by state law and it exceeds our authority. So next slide. So the other issues that were raised in May was a question about the RHC's authority to adopt these regulations. You have a fairly extensive analysis of the RHC's authority as part of the staff report. But just to summarize, Section 1709D grants the RHC authority to establish rules and regulation for the administration and enforcement of the CSFRA. A court reviews an administrative agency such as the RHC's regulations as to whether the regulation is consistent with and not in conflict with the enabling statute and necessary to effectuate the purpose of the statute. Courts do give considerable deference to rent boards in implementing regulations. So although the courts do scrutinize regulations, there is a considerable amount of deference. And I think we saw that in the case on mobile homes. So the proposed regulations are consistent with the CSFRA, and they certainly are within the RHC's authority. And it is our position that they would withstand legal challenge. Next slide. So there were also questions about due process and whether the proposed regulations would violate due process. There is also, once again, an extensive discussion about this in your staff report, so I'm not going to repeat that with all the case sites. But the proposed regulations are related to the legitimate purposes of the CSFRA and the MHRSO. And those purposes are a legitimate exercise of the police power. They don't constitute a retroactive regulation, as they really just clarify what the existing law is. They don't alter the legal consequences for a landlord. I think as we discussed last month, tenants already can file petitions related to base rent and concessions and obtain refunds and rent rollbacks. And we do have petitions that may be coming forward. And finally, there's nothing in these regulations that interfere with a landlord's guaranteed right of a reasonable and fair rate of return. So just to review, our recommendation is that the RHC consider the proposed regulations and adopt the regulations as written. And I and staff are available to answer any questions.
Okay, committee, we will now move to questions from the committee. Do we have any questions? And we're doing questions. Questions first. Okay, I have questions if no one else does. Does no one else have questions? Okay. Oh, committee member Parnavella, I'll let you do your questions first.
Yeah, I mean, my question is just on the point about we wouldn't be altering any of the legal consequences for landlords. And I'm just trying to understand that concept a little better, because it seems to me, if by way of clarifying, that's the word we're going to use, clarifying the CSFRA in a way that now obligates the landlords to accept a certain base rent that they otherwise have not been using for the past 4 or 5 years. There's a legal consequence to that, where if the landlords now don't comply with our new clarified interpretation of the CSFRA, then you know, arguably they are subject to any manner of consequences, whether via a petition or even through the court process. So I'm trying to understand that concept, because to me it certainly seems as if we adopt the regulations as drafted, we're certainly altering the legal consequences for landlords going forward in regards to how they calculate base rent, and if they choose not to calculate base rent based on a new clarification of how that should be done.
Well, so the definition of base rent in both the CSFRA and the MHRSO is the rent actually paid by the tenant for the initial term of the tenancy. That language already exists. That language is clear enough, although we did think it was worth clarifying, because people have asked questions about what does the initial term of the tenancy mean. So I think that landlords are facing these consequences regardless of what the RHC does. I think a tenant could bring a civil suit, and I think a tenant could bring a petition right now and get a rollback and a refund of overpayment. So in some sense, the regulations that we are proposing limit those consequences to limiting the refund to only 12 months, whereas potentially a tenant could collect at least 3 years, and depending, I think it would be 3 years, but we don't have any court rulings on statute of limitations in this context. So maybe a tenant could make an argument to go further back.
Okay, and then, I mean, but ultimately something like whether to go a year back or not, that CSFRA is silent on that. So that's not us clarifying anything. That's us making policy and saying we've decided as a policy principle we want to do X, Y, and Z. That's not clarifying anything. I mean, is that fair to say in terms of the 1 year going back?
I think that's expanding on the intent and purposes of the CSFRA and the Mhrso, which are to protect tenants from excessive rent increases and to provide landlords with a fair rate of return. So when you look at both of those policies, I think you're within your authority to include that.
Okay, but I mean, I think it's one thing if we are looking at the plain text of the CSFRA like we've been doing and saying some people find ambiguity in this, so let's clarify that exact language, as compared to saying now we're going to introduce a new concept, which is whether we should go a year back or 3 years back. I mean, that seems to me more of a policy decision, but maybe it's not the proper time for it. Just my last question, while I have you, on the trouble damages issue, just to clarify that, my understanding would be that tenants are still and will still be entitled to seek triple damages against landlords with the regulations that are proposed. The only thing is that, as always, there's a high standard you have to meet in order to secure those types of damages if you're in a tenant's position. But we're not doing anything in any way that insulates the landlords or otherwise protects them from tenants who, going forward, after we enact these regs, might come after them and, among other things, say, I want triple damages against you, the landlords, because of how you treated the base rent. I mean, is that kind of a fair statement?
Yeah, that's fair. That is in the CSFRA right now. We are not changing that language. We were just trying to answer questions that were asked in May.
Okay, thank you. That's all I have. Thanks.
Okay, Committee Member Greenwald.
Sure, thank you. Could we pull up slide 16? I had a question about that. And I'll start talking as we get there. But my question to staff is, if we were just discussing the discretion of the RHC and the options that we have to clarify, and in the straw poll, we had discussed potentially differentiating between the different types of concessions. So in example one, right, that would be a move-in concession, where it's really, this is 2 months free, but it'd be a one-time concession of 0 with several months, a different term or base rent for the months afterward, versus number 2, which is a 25% discount. And I think in example one, I think that's where a lot of the energy I've heard from the community has been, that a move-in special or a move-in concession has a different purpose as the second one, where that is tougher to defend. It really just does seem like something that's meant to get around rent control. My question is, if we did differentiate, would the RHC have the discretion to say that the clock for a move-in special begins at that first month for 12 months, and then the rent increase cannot be given at all until the first 12 months at that rate has been paid? So what you were saying in the last example, that we are clarifying and in some ways potentially also setting policy. Would it be within the bounds of all the definitions that are in the CSFRA for us to say, in these certain situations where a concession has been given at 0 in the first 30 or 60 days, that landlord would not be able to increase the rent until the 13th or 14th month of the tenancy until that amount has been, the full amount has been paid for 12 consecutive months. Is that something that we would have the discretion to do?
So I want to make sure I'm understanding it. I think what you're saying is, could we essentially ignore the first month as part of the initial term if that was a free month of rent? Is that, am I characterizing that correctly?
Yeah, I think that would be the, if we're controlling the rent increase amount, right? And where the intent is to not allow for unexpected or rent increases that are outside the bounds of the AGA. I mean, essentially that first month could be considered non-rent or no rent. I guess, do you see that infringing upon another part of the CSFRA if we were to go that direction?
I don't want to give a definitive answer because I want to think about this. I think it's an interesting question. I think there may be a way to do it, but we would have to think about it and figure out how to make that an effective regulation given the language of the CSFRA. So I'm not saying no, but I can't tell you for sure that I think we can do it. Sorry for the wishy-washy answer, but
no, that's okay. Thank you.
Vice Chair Ramos, did you have a question? Your hand was up and it went down.
I thought about it more and then I decided against asking that question.
Okay, very good. Well, I do have two questions. First and foremost is, and I think where I want to start. So as we deal with concessions, one thing that has popped into my head is we're looking at tenancies beginning after effective dates of CSFRA or Mhrso. But if we follow that strand, so hypothetically, if I was a mobile home resident in March of 2021, and that was my free month, my free month was March because I moved in March 1st. Would that mean that my base rent is zero because that was my free month?
I was hoping you wouldn't ask this question.
Sorry.
I think this is the challenge, and I have to say we may need to come up with some clarifying regulations on this as well, because that is one interpretation. What both the Mhrso and the CSFRA say is it is the base rent in effect. It doesn't define in effect, and that essentially is the entire sum of what it says. So it doesn't have any of the additional language or tenancies that commence after those dates that we have in the other definitions. So I think that would be an absurd result to come to that essentially would penalize landlords. It's not within the intent of either the CSFRA or the Mhrso, which is intended to ensure that landlords get a fair rate of return. But I acknowledge that the language causes some challenges.
Okay. And that was kind of what I thought. I mean, it is an absurd result, but it is effectively, I think, where then we go to. My other question was, as I was going through here, I'm trying to think of how to phrase this, sorry. Okay, so as we're thinking about the retroactivity and we're thinking about, do we do anything to potentially limit? I tend to understand that based on the plain language of the CSFRA, base rent and rent may have slightly contradictory definitions there beyond periodic versus actual paid. By looking at retroactivity, do we put ourselves in a situation where someone could say that we don't have the authority to do the retroactivity step, meaning if the CSFRA cannot be used to restrict any benefit that the tenants receive from it, would putting in the retroactivity language effectively restrict the benefit to the tenant?
Okay, first, I just want to say it's not a retroactive regulation, just to clarify, because that has a very specific legal meaning. But what we are proposing is essentially a statute of limitations. We did look into your authority to do that. We think you have authority, but once again, there is no case law on this. There are other rent stabilization jurisdictions that have some forms of limitation on recovery for tenants in terms of overpaid rent, or have similar provisions like what we're also proposing, that former tenants have to file a petition within a set period of time. So we think it's within your authority, but once again, I can't cite to a case because there isn't one. And we did contact a couple other rent stabilization jurisdictions, and everybody said, yeah, we think that that makes sense, but we've never looked at it. So.
Okay, thank you. Does anyone else have any questions from the committee before I move on to public comment? Oh, committee member Pardeziella.
Yeah, on those other jurisdictions that you mentioned to contact, did any of them have anything? I think it was Richmond and Berkeley, perhaps, were some of them, but did any of them in any way address a circumstance that we're in here, or are we really in kind of uncharted territory as to this specific issue? So did any of them ever have the specific issue of clarifying how base rent was going to be defined, and then taking that second step of saying, well, how far back are we willing to permit, recovery in terms of, statute of limitations purposes? Has anyone else kind of dealt with that, or are we the first as far as we understand?
So several of those jurisdictions have clarified base rent. I think we provided you with that information last month, including Berkeley, Richmond, West Hollywood, and Santa Monica. I did go back and check their regulations. I could not find any that then limited the tenant recovery amount. We did have some discussions today with Richmond and West Hollywood. They take the position that just like any other petition for downward adjustment, there is a 3-year recovery period for overpayments. So I think Mountain View would probably be the only one that is limiting it to a 1 year, whereas those other jurisdictions would allow a 3-year recovery. And I did check, and this was in response to a question from the chair, several of those jurisdictions, in particular, Berkeley and Santa Monica, adopted their clarification many, many years after their ordinances were adopted, but in particular, 5 or 6 years after Costa-Hawkins went into effect, which is what really impacted this issue for jurisdictions that had rent stabilization pre-Costa-Hawkins. So very similar situation timing-wise to what Mountain View is doing.
Thank you.
Okay, I have one final question, but does anyone else on the committee have one before I ask mine? Okay. I know that this issue has mostly arisen because of perhaps concessions given during the COVID times and various things that we've seen as of late. But rental concessions are not new in the industry. I think my first, I'm going to call it my big girl lease, like after I was out of college, had a rent concession in it. And that was many, many moons before COVID. Do we have any concerns? And I don't know if this is maybe more for Anki, that this question has been asked in since 2015 by a landlord or a tenant and was answered differently than it's being answered now, meaning that we may have a tenant or landlord who was advised that the concession did not need to be reduced, maybe in 2016 or 2017, and was operating under that assumption.
We have not encountered those questions in the beginning of the CSFRA being effective, because we try to signal any questions that are coming in and where clarification might be beneficial to the public at large. So this past months have been the first time that these issues were brought up to us, at least. Yeah.
Thank you. Okay. Seeing no more questions, raise your hands if you have questions. I am now going to invite public comment. Would any member of the public on the line like to provide comment on this item? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen and perhaps help me keep the commenters in order so I don't lose track of them. Thank you in advance, staff. Okay, I believe that Salman had their hand up.
It's got cat vomit in it.
Hi, my name's Salim. I want to thank you for the opportunity to speak. I am a renter in Mountain View. I started going to local government meetings because most of my friends have been priced out by the housing crisis. I want to thank staff for the work they've done. It's extremely thorough. It's remarkable that they've done so much work, even meeting with stakeholders. And it's clear in the staff report they've created. What you have before you today is not a policy decision. The policy decision was made when voters in Mountain View voted for Measure V. What's before you today is a question of what the law is, and it's pretty clear what the attorney for the city, believes the law says. I think it's clear as day what Measure V says. And it's remarkable to me that so much has been said about, basically to rationalize a decision made by landlords who had not carefully read the CSFRA. It's unfortunate that they didn't read it clearly before, investing perhaps tens of thousands of dollars or banking tens of thousands of dollars on that decision, but that's not relevant in your decision making today. You have to implement Measure V as written. Thank you.
Thank you very much. And next is Tim.
Hi all, I'm Tim, he, him pronouns. I've been a Mountain View resident for since 2015. I've happily voted for rent control. It was awesome. And I want to clarify a little bit. I'm a little confused. It sounds like from what I've heard, if a landlord stole rent money from a tenant, either through malice or through poorly reading the city charter, then there is a policy decision being made tonight to limit how much a tenant could get back, and making a decision to make it only back to a year. So there does seem to be a policy. It seems pretty clear what base rent is. I'd thank you, staff, for doing all this work to really clarify the way that you've been implementing this for so long. And it just seems almost like a waste of your time and talents. And it seems again, that the policy decision at issue here is whether or not to limit back pay to 1 year or to leave it to statewide limits, because that does seem to be an actual policy decision that's being made by RRC, whether or not to limit what tenants would be able to get. So thanks. Looking forward to having this clarified.
Okay. Karen, do you want to clarify there or should we continue? Okay. Next,
yeah, we should continue.
I see Sky.
Excuse me, I believe Sky has a presentation. Is that right, Sky?
So yes, I'm requesting 9 minutes. I'm representing 5 people. So if they were all to talk, that's 15 minutes. We've done a lot of research about the economic impact of this policy. So that's something the board has requested and I'm ready to give it to you if you give me that time.
Certainly, Sky. And can we get Sky's presentation up for her too before we start our counter?
So can I share my screen? I have it ready to share. This.
So does the chair want to make a decision about whether Sky can have 9 minutes? Your rules do provide that if a speaker is representing 5 or more persons, so those people have to give up their time to speak. You could, as chair, grant her up to 10 minutes.
Yes. Sky, can you name your individuals? You don't have to use last names, but just first name.
Yes, I can. So there is Tessa, there is Helen, there is Anna, there is Bernardo, and there is Marie.
Perfect. And they would have all appeared if they had not thought that you could speak on their behalf?
Yes.
Very good. Then we'll give you your 10 minutes.
Thank you. I really appreciate that. So as I was saying, this is a rental housing impact study, an economic analysis of the proposal to average the one-time rent concessions, all one-time rent concessions into base rent that it will have on the city of Mountain View. So to get us all oriented, the Rental Housing Committee intent and purpose is to fulfill upon the Community Stabilization and Fair Rent Act. And the 2 main objectives in that Rent Act are affordability for renters, as well as ensuring a fair and reasonable return for landlords. The first part of this study, we're going to look at the affordability for renters and what that impact will be. So the impact of this regulation, were it to go through, is that landlords have stated overwhelmingly that they will no longer be providing future concessions. So with this in mind, the industry standard of often providing 1 month free concessions is now taken out from the possibility. So we're going to look at what impact that will make. So the ultimate impact is that relocation costs into Mountain View will become financially prohibitive for the median income people in Santa Clara. So that means 50% of people in Santa Clara County will face financial hardship with the possibility or desire to move to Mountain View or relocate within the city. And to break down how we're looking at this, it is a short-term acute financial hardship that would occur. So the median household income, if we look at that for Santa Clara County, is $130,000. That breaks down into an after-tax amount of $7,318. The average household, or excuse me, median household savings is $2,000. That means there's approximately $9,000 available. The relocation costs increase the total housing costs because you have deposits and moving costs, and that is estimated to be around $6,000. You can take a look at the Excel sheets for that or ask me any questions about those assumptions, but they're well researched. That means the remaining funds are $3,049. And the average living expenses for a home, for a family is $3,158. That means net funds without any concessions is $333. So if any health issues come up, any unexpected costs come up, we are talking about a short-term acute financial hardship and risk to those renters. If a 1 month concession is provided, these households are able to retain their savings and have a net funds available to them of $3,460. ultimately, the impact of removing these concessions is that many income people will choose to move to neighboring cities such as Palo Alto, Sunnyvale, and Cupertino because of the financial stability and flexibility that concessions provide. This means the regulation impact is that it violates the goals and objectives for creating affordability for renters because it is making it less affordable for the average renter. The second portion or purpose commitment that the Rental Housing Committee has is to also ensure fair and reasonable returns to landlords. So I want to remind the committee that, or let the committee know that many of these landlords are elderly. This represents often their life savings and they rely upon this income to meet their monthly needs. So you guys have a very big impact in whatever you vote. To examine the impact that this regulation would have on the bottom line, we took a look at a typical 10-unit complex. We made the assumption that a good faith type concession was given at move-in for every tenant. So a 1-month free single concession with no renewals. The tenant duration mix would be, in this example, 5 tenants moved in 2022, and the other 5 tenants had moved in prior. That means all 10 tenants would receive a rent reduction in 2023, and 5 of said tenants would receive a retroactive payment for a year based on the new regulation. So the ultimate impact to the landlords is truly unfair and unreasonable in that it creates a 29.5% decrease in income. This is huge. And this is for only the average landlord. So other people can be more than this. So moving on to how this breaks down. So you may think that you're just voting on a 1/12 reduction, but the issue is that the costs remain the same. So it multiplies the impact. So that is what I'm showing here. And again, you can take a look at the Excel sheets for further detail. And this does also take into account the annual increase. All of that is included. So in summary, the proposed regulation as it stands will substantially impair affordability and access to housing to middle income individuals looking to move into or relocate within Mountain View. The proposed regulation, if applied retroactively, will substantially impede upon the landlord's ability to achieve fair and reasonable returns. So the regulation impact actually impacts both main tenets of the Community Fair Stabilization and Fair Rent Act of the Affordability to Renters and the Fair and Reasonable Return to Landlords, hurting all parties involved. So one note before I go into our recommendations, but this is simply an economic analysis and does not imply the legality of implementing the proposed regulation at all, simply looking at the economic impact. That said, there has been concerns shown, but ultimately I understand that there have been some landlords, and I think it is the vast minority of landlords who have created concessions as a way to get around rent control. And that does remaining limited, and that does mean, the tenants do need to be protected. And for that reason, what we would propose is to simply limit the scope of allowable concessions to 1, stop annually renewing concessions, and 2, to stop the amortization of concessions. This would both provide safety for the tenants and the renters. It would enable the beneficial impact to the renters of the through the move-in specials, and make sure that the landlords are able to have a fair and reasonable return. So again, benefiting all parties. So just thank you for your time. Thank you for listening, and thank you for, I know you guys really care about the community. I was born in Mountain View. I care about the community as well. So I do want renters to be taken care of, and ultimately the best way to do that is to take care of all parties involved. So if you have any questions about the economic impact, please let me know. If you have any concerns about the study, I am an economic researcher. I've done that for a living for many years. So, you know, a lot of work was put into this, and yeah, just please let me know any questions. So that's all I have. Thank you so much.
Thank you, Sky. And moving on to Shauna.
Hi, can you hear me?
We can hear you.
Wonderful. Thank you for allowing me an opportunity to speak. I am a rental housing provider in Mountain View. Again, my name is Shanna. This is a really challenging time to be a landlord. I'm sure you've heard that many times. Rents over the last 2 years at my properties in Mountain View dropped $600 or more a month. That is very significant. In a time where people were moving out of California, moving out of Mountain View, moving out of the MSA, it was challenging to get people back into our homes. So we did have to rely on concessions like most of those landlords in the market had to do at the time. We did read the agreements, we did read the regulations, and nothing in there would have told me that I would be asked to give back money, right, that I've already lost. I've already given out concessions. I could not have fathomed that we would be sitting where we are today. And I'm sure the people that have lived here for a long time are more agreeable to this kind of thing because they probably experienced concessions in the past and this is a windfall for them, but not for the new people coming in. I can tell you we do not do amortized concessions. We do them up front because people need them to move in. They need them to mitigate the cost of a truck. I need that. I need people in my buildings so that I'm able to pay payroll for the people on site, to take care of the work orders that are on site, to invest in my property, to keep it looking clean for the renters that rent with me. I find it very challenging to hear that you think people are already filing these petitions about concessions. And if so, if people are getting money back because of the concessions, why do we need this as it's written today, right? If that is something that's happening. And I haven't seen any data to back that up. I can tell you, I've had my building for a very long time and I've not seen that come to fruition. I would ask you to really consider what this does to a landlord. Be fair to those of us that have acted in good faith and understand that renters as well as landlords have been impacted during this time. I implore you to think about how you would handle it if your employer asked you to give back money that you had earned, right? How would you feel about that? Where would you come up with that? We're not talking about a 4-property complex. We're talking in some cases, even if it's 10 or 15 units, that is a lot of money. Thank you for the opportunity to speak. I encourage you to reject the retroactive nature of the proposed regulation, and I appreciate your time.
Thank you very much. Okay, Edie. Edie is next.
Hello. Rental Housing Committee. There is a need for you to interpret the CSFRA and MHRSO. Sometimes their wording may not be what everyone expects, but as you know, that does not provide you with an opportunity to rewrite them. If you were to ignore 2 months free of rent for a new renter, then would you say the initial tenancy does not start until 2 months after the keys to the unit were provided? Doesn't the tenant have a lease for the first 2 months? Of course they do. Their initial tenancy includes the period of free rent. Any other interpretation is convoluted and strays from the wording of our rental ordinances. To landlords who want to end up with a rent of $1,000 in months 13 and want to provide 2 months free, they can do it. They need to start renting the unit at $1,200. Here is their marketing: 2 months free, then pay rent of $1,200 and a rent decrease to $1,000 beginning in month 13. Mountain View apartments will still be rented, including after you pass the staff recommendation regarding base rent. To the landlord example of giving a move-in of cash payment to renters, it is hard to see this as paid by the tenant. However, while I hope you will adopt the proposed regulation tonight, you might ask staff to come back with additional language to prevent abuse of the CSFRA by large move-in payments to tenants, allowing the tenant to pay an inflated initial rent and enabling an inflated base rent so that future rents become let's make a deal. Your legal staff has recommended flexibility regarding retroactive return of rent to tenants related to concessions. I support this. I would not reduce the potential return available to renters below what is proposed, and you might consider more than a 1-year return in the case of hardship, as you have done for other regulations, giving this discretion to hearing officers. And of course, the MNOI fair rate of return is available to the landlords who are impacted by not this change, but this clarification and interpretation of the existing language in the CSFRA. Thank you.
Thank you, Edie. Okay, Lauren.
Good evening. My name is Lauren Zach. I use she, her pronouns. I am a housing attorney. I'm barred in the state of California, and I practice in San Mateo and Santa Clara counties, including in Mountain View. I have read the CSFRA very carefully, and I support the staff recommendation as a clarification of the existing law. It is completely consistent with the language and the intent of the CSFRA. I know some folks are proposing policy changes that may or may not be good policy, but a good first step is just to restate very clearly what the CSFRA says, and that is what this proposal does. So thank you for your time and consideration.
Thank you, Lauren. Okay, moving on to Anil. Anil Babar, can you unmute yourself?
Yeah, can you hear me now?
We can hear you now.
Okay, thank you. Hi, my name is Anil, and I wanted to speak against the proposal that you are evaluating today. I wanted to address the impact that this proposal will have on owners and many other owners in Mountain View. The proposal you have before you is punitive in its approach. First of all, concessions are an acceptable business practice used to lease units, and that's important in this particular market. These concessions were being provided with no expectation that one day you would deem them illegal and force owners to pay retroactively on the amount that you will determine. Most importantly, concessions are a valuable tool for tenants to ease the transition of moving. They are a win-win for both tenants and property owners. What you're proposing is a lose-lose for both the owners and the tenants. Owners provided concessions in good faith, and tenants accepted them on a mutual basis. I would encourage the commission to reject this proposal. Thank you.
Thank you very much. And we'll move on to Joshua.
All right, good evening, Madam Chair, members of the committee. The CSFRA was sold to the community as a tool to stabilize Mountain View and bring an end displacement, or at least prevent displacement. Since that time, many Mountain View housing providers have been operating in good faith to work with residents to make housing accessible. Upfront rent concessions that take the form of 1 to 2 months free rent help reduce moving costs, make housing accessible, and are consistent with the stated intent of the CSFRA. Upfront rent concessions do not reduce the periodic payment of monthly rent. Adopting this regulation as drafted means rental housing providers will be very leery of continuing to offer upfront rent concessions. Rather, you should look to treat upfront concessions differently from ongoing concessions, and tenants will know upfront what they're paying and how much they can anticipate their rent increase will be. There's a clear distinction between the upfront concession and the ongoing concession. Secondarily, the retroactive application is punitive to housing providers who acted in good faith. They were acting in compliance with the CSFRA. They believed that they were able to offer concessions and did not think that 5 years later, the Rental Housing Committee would come to them and demand they roll their rents back again and give thousands of dollars in refunds to their residents. Tonight's regulation, if adopted, tells owners who gave a concession, you're now in violation of the CSFRA. You're now subject to thousands of dollars in penalties that you never anticipated and never budgeted because you were all along acting by the rules. I also believe that you should look carefully at the peer cities. In your earlier analysis, you did look carefully to Berkeley, Richmond, and West Hollywood. While they may regulate concessions, they did not amend their petition process to allow for retroactive application. The committee tonight should really recognize the importance of concessions as a key tool to provide housing affordability, to provide housing stability, and to make it easier and attractive for residents to move. The regulation tonight will stop that practice, will make housing more expensive, and will penalize housing providers who lawfully acted in good faith by requiring these refunds or rollbacks that were completely unanticipated, unbudgeted, and not foreseen. I'd encourage you to look at this very carefully and to consider the prior input from CAA that we've shared with you over the past several meetings. And thank you again for your service to the RHC, and thank you for continuing to work through this issue to find a balanced solution. Thank you.
Thank you, Joshua. And next is Matthew.
Oh. There we go. Can you hear me, I hope?
We can.
Wonderful. So I'd just like to make my comments to some of the board members who are in favor of including concessions in the base rent. You know, I understand that you've accepted the consequences to landlords, and that doesn't seem to bother you very much, but I want you to think about the consequences to tenants. New tenant today may receive a rent concession for a month of rent, which we'll say is $3,000. A tenant moves in, and they immediately save $3,000. Can't make this any more blunt. Concessions are gone if you include it in base rent. So that tenant that just received $3,000, and then they can use that money for moving expenses, that money is now gone. They're not going to get it anymore. So I need everybody to understand, if you're voting to include concessions in base rent, you're penalizing every tenant who moves in later on. Yes, it's a windfall for the tenants that are there now, but this is penalizing landlords today, but you'll be penalizing tenants forever because we will eliminate all concessions. Please think about that when you're making your vote. Thank you.
Thank you, Matthew. And next we have a number ending in 872.
Yeah, hi guys. I just want to say thank you for all your efforts. I'm a longtime renter in one of Mountain View's mobile home parks. My comments tonight have to do with the notion of fairness. RHC really needs to do what's fair, and in my opinion, the current staff recommendation is not fair. Great idea to adjust base rents for those who got a concession, but only if you do so fairly. So I ask each of you, why would you limit such an adjustment to new residents only? Discriminatory, it's unfair, and it runs counter to the spirit and intent of the MHRSO, which was to create stability, fairness, and predictability in the market. And I believe RHC has the power to fix this. With staff's current interpretation of the MHRSO, any renter who signed a lease prior to March 16, 2021, that ends after that date is not entitled to any adjustment of base rent due to a concession. This will impact dozens and dozens of families renting mobile homes in Mountain View. How is that fair? Staff is saying only new renters who signed leases on or after March 16, 2021 would be covered by any RHC decision to alter base rents to accommodate for concessions. Effectively, such a ruling would discriminate between old, longtime residents and new residents and how they are treated. And this is kind of directed, I guess, at Karen. There is more than sufficient legal room for a broader interpretation of the ordinance, such that longtime residents and new residents are treated equally when it comes to concessions. Legal says base rent for old residents is the rent in effect on March 16, 2021. But that doesn't mean base rent can't be adjusted for concessions, because the rent in effect is effectively less than the rent stated on the lease agreement because a concession was provided. So if you say your hands are tied, but your hands aren't really tied, there's ample room for RHC to adopt a broad, inclusive definition of rent in effect in Chapter 2C1 of the MHRSO to account for to account for concessions for long-time residents. So please, make sure all residents are treated equally. The language in the ordinance does not prevent you from doing this. Thank you so much for your efforts. I appreciate it.
Thank you, caller. And as we move on, I'm just going to mention that if you already provided commentary on this item on 9.1 earlier, we are only doing one round of commentary. So next is Jeff.
Good evening. I want to say that can you hear me?
We can hear you.
Okay, moving. All right. The landlords knew the rules. Landlords followed the rules. Landlords followed acceptable practices used in other 481 cities and 57 counties throughout the state. There's no clarification needed. It was very clear what the rules were, and now you're looking to change them. This is not a clarification. This is another way by the biased staff to retroactively punish landlords. Plain and simple. This is bias, and you've got the votes to do it, and you all know it. Why do you want to punish landlords so badly? Maybe you ought to start out explaining that one. Why do other jurisdictions have the Redskins rules and none others? There's only three jurisdictions that have it. Straight bias and hatred toward landlords. Disgusting. If you need to clarify it going forward, not going backward. There's no reason to go backward. If we go forward, we know the rules. We play by the rules. Easy, said and done. Now, 5 years later, you want to go backwards? It's a bunch of BS. Here are the unintended consequences. I'll be straight up with you. It's going to pass. We know it's going to pass because you're biased and you will pass it. And going forward, there will be no move-in specials ever again. Income qualifications will be 4 times, 5 times rent. double deposits, one person per unit. And we'll rent to only techies that work at, Facebook, LinkedIn, have $200,000 salaries. We'll gentrify the buildings right under your noses. When rents drop, and they will, we know they will at some point, we are going to refuse to do rent concessions or reduce rents. And any tenant who doesn't want to pay for it is going to leave. And you're going to have, and which is exactly the opposite of the intended goal of the CSFRA, is to retain tenants. When rents drop, we're not dropping the rents, and they're going to leave. So you're going to get what you vote for. Thanks.
Thank you, Jeff. And Kevin is next.
Evening, RHC members. My name is Kevin Ma. I'm a resident of the city, and I recommend what staff has brought up to you. Today's question is a question about clarification of what the current text of the CSFRA is saying. As one of the speakers previously mentioned, it's not really a policy question. It's more of a, what does this actually mean, so that we don't have to deal this out in court. It is good on all sides to ensure that tenants have the knowledge of what they're getting themselves into at first. We don't want to be leading to a situation where suddenly there's like a massive rent increase functioning that happens at the end of the day that they perhaps did not know about, because things can happen over a year. And if concessions are really what is necessary to bring people in, there's nothing stopping a reduction of rent, right? That's still the option. And even if a rental provider is facing issues with the overall dealing with the property, there is already a process under the RHC to provide a fair rate of return. We already have a process for it. It can be done. We don't need to be creating more disruption for now. So I do recommend what staff has brought up for you, because we've gone through already a public process over this. We've gone through workshops, and what staff has brought up is reflective of the workshops. Thank you.
Thank you, Kevin. And we'll move on to Alex N.
Hello, can you guys hear me?
We can hear you.
All right, awesome. So I've been living in Mountain View for a few years now. I was able to have the privilege of voting for the adoption of the Csfra via passage of Measure V in 2016, and actually see through a much staggeringly greater percentage of support of renter protections in Mountain View, a 70% voter rejection of Measure D in 2020. So in terms of, we keep hearing letter and intent. In terms of intent, the voters of Mountain View are making it abundantly clear that they intend to see apartment and mobile home park renters protected against excessive rents in Mountain View, while assuring that landlords can recuperate a fair rate of return. In terms of the letter of the law, that is beyond clear. That's literally in the law. Both the Csfra and the Mhrso say that the initial rental rate means only the amount of rent actually paid by the tenant for the initial term of the tenancy. It's literal. It's there. There's no debate about this. That's not the debate that we're having today. But I think a lot of what a lot of speakers are kind of discussing without necessarily, if we were to give a name to it, it's the context around the Csfra and the context around what it means, the perspective around who is it fair to, who is it not fair to. And just to be clear, when we passed our rent control laws, we passed that within a city that not only operates within, but also acknowledges that our nation is based on a free market economy. And that means that business owners, landlords are business owners, just like any other business owner, they must be appropriately rewarded with profits against the risks that they take on when they provide goods and services. The Csfra has been challenged in court on those grounds thoroughly, and it has been thoroughly upheld with its language surviving intact because it has been found to be fair to landlords in furthering the will of Mountain View's voters, which is to protect vulnerable residents and renters. So when I'm kind of hearing, like Ms. Sky Moreland's discussion around housing affordability. Hey, like, guess what? That's only going to be affordable up front, but as rents compound in the future based on a higher base rent, then that's actually creating far less affordability over the long term. When I hear Mr. Anil Babar say, quote, in this particular market, concessions are needed. There's no force majeure clause in our rent control laws that say we make exemptions for base rents in the event of once in a century plague or a Wall Street implosion. And, when I hear Mr. Josh Howard say you're acting in good faith, yes, probably, but were you acting in compliance? No. So please support staff recommendation tonight. Thank you.
Thank you, Alex. And next we'll hear from Teresa M.
Hi, everybody. Can you hear me?
We can hear you.
Hi. Good evening, everybody. This discussion is very important, and it affects housing providers and residents. And I'm grateful to hear the input, and I'm grateful to RHC staff and to all of RHC members for, allowing the type of discussion to be had, because it really is important. My comment is really going to the language of CSFRA itself. If the language of CSFRA is as clear as RHC staff says it is, and some of the other speakers say it is, then no need for clarification. But the reality is the proposed amendment is a change. It contradicts the definition of rent in CSFRA, which specifically includes periodic payments of monthly rent. A one-time temporary move-in or renewal concession is consistent with the purposes of CSFRA. It most definitely removes barriers to housing and preserves housing stability. And it does also help the housing provider by bringing residents into the homes. And so it is a win-win. And in terms of the residents' budget, they know full well what their actually monthly rent is, that periodic payment that is the specific language that is used in the definition of rent. And so when I hear that base rent is the quote unquote rent actually paid, it has to be read in conjunction with the definition of rent, which does include that periodic payment. And so, I will leave off with two comments. First, a one-time temporary rent concession really does help everybody. We shouldn't penalize anybody for that. And comment two is that this should not be made retroactive. You really are punishing housing providers who've tried to do the right thing and who have complied with CSFRA and who have been given no indication of any kind that what they have been doing is improper. Thank you again, everybody. I really appreciate your listening and your input.
Thank you, Teresa. And next we have a caller on the phone ending in 060. Caller, you will need to unmute.
Hello, can you hear me?
We can hear you now.
Okay, yeah, hello. My name's Eric, and I actually work at a apartment complex, and actually I was one of the ones that set some of these rental concessions during the COVID time. So I just wanted to give you my perspective of it and just leave it at that. I did read very carefully the CSFRA text, and before we did offer some concessions, and it says the term initial rent means only the amount of rent actually paid by the tenant for the initial term of the tenancy. Now we do month-to-month tenancies, and so I just read that and I said, oh, well, the first month is, we were giving a concession after 6 months. So we just read that and said, okay, well, it's the base rent is whatever's on the contract there, and I just left it at that. And I realized that I should have called you guys and asked you for clarification at that time, but we didn't. And so now here we are. But by my reading of this is that the initial rent is the periodic rent on a month-to-month thing. I never saw anything that said in a month to month, it was the 12 month. And, you know, I looked through the whole thing and searched it, and maybe there's some other documents than the ones I downloaded, but I just wanted to leave it at that. Thank you.
Thank you, Eric. And we'll move on to Anna Marie.
Hello, can you hear me okay?
We can hear you well.
Thank you. I'm Anna Marie. I use she, her pronouns. I'm an over 40-year resident of our beautiful city. As a 9-year mobile home resident, I like to echo everything that Edie, Alan, Alex N, and the mobile home renter who spoke on the phone said. They said it all perfectly. You know, over the span of 40 years, I've watched our city change a lot. And as beautiful as some of those changes are, not all of them have been great. I've seen a lot of my neighbors, friends, family priced out. And I understand that landlords want to make a profit. You know, we live in a free market, that's all agreed. But the CSFRA is very clear, and it was created in a way that was supposed to be fair for tenants and landlords. And I find it interesting that many landlords have not understood the CSFRA. I'm sure some of them may have had access to lawyers or other resources to help them. That being said, I am urging the RHC to not limit the recovery amount or time for tenants. Please listen to staff recommendation and be flexible with this. Yes, thank you so much.
Thank you, Anna Marie. And next we'll hear from Violet.
Hi, yeah, I'm a Mountain View resident. Can you hear me?
We can hear you.
Okay. Okay, well, thank you, RHC, because I know you have a very difficult job. And, you know, from my perspective, what that job is having at almost every RHC meeting to have landlords ask you to relitigate something that's already been passed. And that is what is happening yet again today, and I'm exhausted. I have lived here for many years and definitely fought alongside folks for rent control. And it's very clear. Let's not gaslight ourselves. Yes, we live in this political climate today where agencies are captured. One of our Supreme Court members has a wife that started to support January 6th, but let's not get in our heads that it's okay to treat bodies that are meant to not to legislate, but to uphold the law as these corrupt agencies. The California Apartment Association has a lot of power. I believe smaller landlords didn't understand this, but I do not believe Joshua Howard or the California Apartment Association did not know that this was a way to get around rent control. I know him, he's very, very smart, and I actually have a lot of respect for his intelligence, but I am tired of the BS, and I'm being nice by not swearing, that we're even having this conversation. If we need an emotional support group for landlords before and after these meetings, great, but we passed rent control and it is the RHC's duty to uphold it. That is it. It is very clear what the law says, and it is an activist move of this agency, the RHC, if you do anything but uphold what we as voters have passed. So my ask for the RHC tonight is to be the most amazing people that you are, and I know you get bullied a lot, and I'm sorry that I might be coming off as bullying you. I will say I will stand with other tenants in a lawsuit and finding plaintiffs for a lawsuit if you choose to go in any route that undermines something that we fought very, very hard for as tenants. The issue is, what is your job? And it is to actually interpret what it is, whether you love it or hate it, and whether landlords or tenants or anyone loves it or hates it. If this is going to change, that would have to be a charter amendment. And that would be the route to do this. So whether we agree or not, whether we have compassion or not, please, please, and I would ask the landlords and the California Apartment Association to stop trying to attack rent control across the state. And here in my city, that is what the law is. So please show some respect and get to know some tenants and get to know the hardship that they have. And I know small landlords don't, definitely didn't, do this intentionally, but I do believe California Apartment Association probably gave them some good strategies that they thought they get around rent control laws in Mountain View, and I'm tired of it. So please uphold our law, whether you like it or hate it. Please, please do what you are tasked to do and go against the state of affairs in our country that undermines that, you know, we need to uphold the rule of law. So thank you so much and have a good night.
Thank you, Violet. Okay, next we have Scott A.
Chair, can you turn that on? I do have that Scott A commented on 9.1 during oral communication.
Oh, okay. Sorry about that.
No, Anki.
I think that was about vacancy control. So
I was also under the impression it was more around vacancy control. Scott A, we'll bring you up. You can comment.
Thank you for allowing me to speak. Yes, the initial comments were more general about vacancy control and specifically section 1718 and how that provision of the CSFRA needs to be given equal weight in all discussions, regardless of what they are. I pointed out a few specific applications to 9.1, but that was the brunt of my comments was specifically focused on asking for action by the RHC to address that specific decontrol section of the CSFRA. And that has a big impact on everything that we do. Obviously, over the last couple of years, that has been a huge factor. And I think a lot of what's being discussed here could be alleviated and get some clarity if the RHC would look at that carefully and consider that the excessively suppressed rents and high vacancy during that period certainly had an effect on everyone, both tenants and landlords. Outside of that, specific to this point, not having one-time concessions be what they truly are and be able to do early in a tenancy certainly injures landlords compared to other Mountain View rental properties not subject to the CSFRA. Others can provide a move-in bonus, 1 month free rent or what have you, and not be a permanent forever annual commitment. If you receive a bonus at your work, you say thank you and you smile, and you don't expect or demand it every year on its anniversary or permanently. It's your salary, and that's a bonus. And there's rent and then there's bonuses. My concern is, as proposed, landlords cannot help tenants during the initial term of their tenancy without a permanent and detrimental effect. So you tie our helping hands to the extent that many of us know all of our neighbors and live with them. Please provide a way that we can make clear assistance without resorting and submitting them to feeling like they're under the gun. That if we provide any relief to them, if they get in trouble at any point in time in that first tenancy period, we can't do anything for them unless we do it permanently. Accept that as a permanent, benefit to them, and it's not, certainly one way to do that is to ignore that free rent period or just somehow have something that we can be clear. I think that's the most important. The reason we didn't face this in 2016 to 2020 is because people understand one-time concessions. And to the extent that we've been clear with that, I think all tenants and all landlords deserve to have it clear upfront and in writing. Thank you.
Thank you, Scott. And next we'll hear from Stephen G.
Thank you very much for your time. I hope I'm being heard. And basically my situation now I'm going to be describing is this. You hear a lot about the housing providers complaining over and over again about having not understood the rules prior to doing what they're doing, which is something that I find very strange. A person with 2 business degrees, I would figure that the first thing that most property owners would do is either have a very good attorney to make sure that they are taking steps to prevent problems, or at the very least, at the same time, understand the consequences of their actions. Again, as I described before, I have a particular landlord that has seen his property value dropped by 28%. And under the section regarding remedies for petitions for rent adjustments going down, when you have a property that goes down significantly like that, then it is in the writing of the law, it literally says that that is in effect an unlawful rent increase if the property value goes down, and yet you're charging the same rent than the value that you originally rented the property for. In this case, again, it's a property was signed on for $5 million and now it's only worth 3.8. Well, then that would mean that a proportional rent reduction is by default required under the CSFRA, because the fact is the increase in rent that's being occurring is because of the fact the property value went down. Now, of course, what's been really going on here at the same time is that everyone's been complaining for the fact that, yes, the CAA lost the lawsuit against the city regarding the CSFRA. The CAA lost the Measure B argument, and it really lost during Measure D when it turned out 2 out of 3 voters went against them for trying to change the rules regarding CSFRA. Now, of course, the problem that these people are now facing with is the idea that at this point, the interest rates are going up. It's going to cause all their property values to go down. And when that happens, that's unfortunate, but it's also a situation that we are well aware of because of 2007 and 2008. So the bottom line is, these people cannot turn around and say, oh, we're innocent victims and we're trying to do everything for our tenants, when in fact they're doing everything they can to protect their own investments. This is the real grim reality of what's going on here. Thank you very much for your time. And again, I simply say there should be no concept of concessions at this time.
Thank you, Stephen. Okay, and we'll move to Alex B.
Hey friends. From the comments tonight, these regulations seem very important. Given how many landlords seem to be either illiterate, innumerate, or ignorant of the text of the charter, a simple EG clause would be of much greater value than I would have predicted. It's the responsibility of the housing providers to do their due diligence when drafting leases and through the duration of any given tenancy to ensure compliance with local laws. I, for one, am glad that the RHC, their fantastic staff, and their immeasurably patient contracted counsel are here to help them perform this duty. Thanks.
Thank you, Alex. Okay, seeing no more commenters who have not previously commented on this item, we will then move
Chair,
on.
there's still one hand. Chair Livesey. His name's Livesey.
I don't have on record that he had commented previously.
You didn't?
Tim Larson? No.
Okay.
Might have gotten
a different Tim.
Confused with
Might have
Tim
been a different
McKenzie.
Tim. Sorry about that, Tim. All right, Tim, let's bring Tim L in. And I will try not to
No
mix up.
problem. Yeah, no, I actually got confused with the first time as well. We're pretty common. No, thanks everyone. I just wanted to echo what Edie and Kevin and Alex had said. This is just clarifying the intent of the CSFRA as written. The petition process does exist. I think what we've heard tonight is a lot of threats that are very unfortunate in this context. The threats always come. All of these people who act in goodwill are always ready to show up and try to scare tenants or scare the RHC from doing its job. The petitions will be coming. The Mountain View Mobile Home Alliance and others will be helping tenants to write these petitions. And so the only thing needed now is to avoid the headache of having to go through a bunch of different hearings and then having the RHC come back to deal with it. So I urge you to pass the staff recommendations. Thank you.
Thank you, Tim, and thank you for your patience as I rudely skipped you. Okay, now I believe we can come back to the committee. Now, as a reminder, a motion to approve should include reading the following items: to adopt a regulations to amend the CSFRA regulations chapter 2 and 4 and MHRSO regulations 2 and 5 to clarify the calculation of base rent where a rent concession was provided during the initial term of tenancy, and to establish a statute of limitations on the recovery of back rent due where a petition was filed on the basis of unlawful rent related to concessions. So do I have motions? Do I have discussion? Don't all like jump out there at once. Committee member Portadezella.
Yeah, so, my take on this is that we're not clarifying anything. We're making policy now. If we were just clarifying things, we wouldn't have 3 meetings and a workshop and 50 pages of staff reports to clarify 1 line of text in the CSFRA. So I don't think we're clarifying anything. I think we're making policy now. Whether we should be or not is another question, but that's what we're doing. So I think we have to be honest about what we're doing now. This is policy. We're not clarifying anything. So, I mean, if we are talking about policy, I think the first thing that I think of in my mind is the fact that for years and years, apparently there was no ambiguity. Nothing needed to be clarified because the tenants and the landlords were all operating under the working assumption that concessions were not to be considered part of base rent. And then a few months ago, somehow, suddenly there became this issue where people were confused. But for years and years, it seemed like there was no confusion. No one was talking about this. So I think it's one thing to talk about clarifying things moving forward and providing clarity, but it's another thing to say we're going to clarify things in the past that apparently weren't unclear to anyone. So now there's confusion, and we're probably primarily responsible for that now, creating this confusion. But apparently there was no confusion for years and years. So I think it's very troubling to clarify something from years ago that doesn't need to be clarified. No one was confused about this, okay? So I think we can use the words retroactive or not, or whatever language we want, but to say we're going to go back and clarify retroactively, I think is very significant because we're essentially changing, we're creating confusion where there was no confusion to begin with. I do think that concessions are important. We've heard about it from enough people. A lot of us personally have received concessions. I was a renter in Mountain View. I received concessions on my rent. It was important to me. It helped me rent my first apartment in Mountain View. And I think it's spot on, a few of the people that spoke, where they said not having concessions is going to hurt the middle income people and the people that are lower income. People that are high income and are moving here and are making $200,000, $300,000, $400,000 a year, concessions are beer money. It doesn't affect them. But other people, that's going to be the difference between they can rent a unit or not. So we're going to take that away now if we adopt these draft regulations. And it is going to make it harder for, I think, working class people to live in Mountain View. And I think we need to be clear about that, because in a year or two from now, when we see the effects of what we're doing, I think we should know now we should be responsible and we should be held accountable. So I think when a year from now, if the landlords in Mountain View are no longer offering concessions, I don't think any of us on the committee can scratch our heads and say, I don't know how that happened. We're going to know how it happened. We decided to adopt these draft regulations, and in response, the landlords are going to say, we're not going to offer concessions anymore. And middle income people and lower income people are not going to have that benefit. And it's going to be harder for them to live in Mountain View. That's a policy decision. So now we're talking about policy. That's one policy issue to consider. Second related issue to me is there have been landlords that have left Mountain View because of rent control, and there are landlords that are going to leave Mountain View because of rent control. And these draft regulations further that atmosphere of encouraging landlords to bail and to sell their rent-controlled units and turn them into townhouses. It might not happen overnight, but the climate that we've created where at least there's a perception that we're going to target landlords, it doesn't help us in the long term. It doesn't help Mountain View in the long term. And I think we've heard that enough from landlords tonight. And, you know, one of the primary text of the CSFRA is a fair rate of return. And it's hard for anyone to say how a fair rate of return could be squared with the idea that 2, 3, 4 years ago, you pay a certain amount of rent and everyone's okay with it. And then later on, we come back and say, actually, no, you got to give some of that money back. When both the landlord and the tenant at the time thought it was fair and did not have any objections, and there was no ambiguity. So then to come back now and to say, oh, you know what, we're going to take that money back from you. Fair rate of return, it's hard to square those things. And I think we have an understanding implicitly that what we're talking about is making policy, because we are making up out of thin air the idea that, oh, we're just going to go a year back on this, right? The CSFRA doesn't say that. So we know we're making policy now because we're dreaming up this concept that we're not going to hurt the landlords too much because that'd be too extreme. So let's just hurt them with 1 year. And maybe it's, you know, like split the baby and no one will be too upset. But that's a policy decision we're making. But if we can make the decision to just go 1 year, we could also go 3 years back, or we could go no years back. Okay, there's nothing that says it has to be 1 year. So if we're talking about policy, I think the fairest thing is to say, now that there is ambiguity, which did not exist based on everything we've heard, this committee's heard, there was not ambiguity about this a year or 2 years ago. I think now that there is ambiguity, it's fair to say going forward, we are going to consider concessions to be a part of base rent, or at least a type of concessions, maybe ongoing concessions. Going forward, as of January 1st, leases entered into at that time, or some forward-looking time frame where everyone is free to make some sort of decision about what they want to do. But to retroactively say we're going to apply this and then just stop at 1 year is actually an admission that we're just making policy, okay? So for everyone that also thinks we should just go 1 year back, you also have to say, well, why not 2 years back, or why not 0 years back? You have to say why. And so I think that's an admission that this is policy we're making. So I think at the end of the day, a fair rate of return is when both the landlord and the tenants think and believe that there's no problem with that transaction. And for years, no one apparently believed that there was any problem with how this was being treated in terms of base rent and concessions. So now to go back and to change that seems unfair. Thank you.
Thank you, Committee Member Portadella. And next we have Vice Chair Ramos.
Surprise, surprise, I have a different point of view. I think one of the major reasons why we have heard about it more recently is because we had a little thing known as a global pandemic. And that global pandemic caused some rents to decrease and caused some essentially movement within the market. The concern I largely heard was renters who signed in with a move-in bonus of your real rent is this, but we're giving you a 25% off decrease. It's now 1 year since they probably moved. And so it's 2022. And suddenly they're faced with a 25% increase. That is not okay with me. That on a bare minimum basis, not okay with me. If we were concerned about just absolutely just full clarifications, we wouldn't have changed anything from when staff initially proposed it 3 months ago. I think a lot of us are sympathetic to the misunderstanding that landlords may have had, and misunderstanding that tenants may have had regarding this law. And that's why we want to essentially make a softer landing. My understanding, the 1 year statute of limitations addition to the law was so that we wouldn't have the same law applying, because it's really just the definitions, and force a rollback all the way back to 2016 again. That was my understanding, that the 1 year statute of limitation was so that we wouldn't harm landlords that far back. I did have a quick question on how rebates would work. It's very interesting as there's such a level of shock into the system, and the shock was caused by the pandemic. I think we've all agree that was why rents went down last year. It's because of the pandemic and all the people either moving out, unable to pay their rent and therefore moved out, or lost whatever their jobs were. And that caused that confusion. And we don't really plan for global pandemics usually with laws, especially ones that had difficulty to change without a vote of the people. So I am open to looking at how we can soften the blow that landlords may feel under this confusion. However, if we are, and that's why I see that there's a distinction in clarification and policy. We are clarifying this law, and if we want to do a straight clarification, we would have passed the staff recommendation 3 months ago. But we aren't doing that right now. We have asked staff to come back with I want to say concessions, but not really concessions. And I am willing to look at those to soften this landing. There are things that I'm very clear about. I don't want that first example, the 25% off discount. That is a no-go for me. I think that staff's 1 year statute of limitations is an elegant solution. And the 1 month rent, that just depends on the language to me. And we can go from there.
Thank you, Vice Chair. Committee Member Grindelwald.
Sure, thank you. And I will say I had a conflict tonight, but I did stay on to give my comment, so I will have to leave after I give my comment. But I agree with Emily on the situation she mentioned, about ongoing rent decreases. I do think that's just kind of a trick to inflate the rent. And so whatever we would pass tonight, I think, there's probably widespread agreement that something like that shouldn't be allowed. You should never have a 25% increase within the bounds of the CSFRA. I mean, that's just within the intent, I think, and I think voters and the committee would agree with that. Specifically, though, I do with the 30-day, with the move-in concession, 30-day to 60-day. We discussed this last time, and I did hear members of the committee say, things like they believe that the landlords who offered move-in specials were acting in good faith. I heard members say, move-in specials are a common business practice, and today a few have mentioned that they benefited from them as tenants. I haven't heard that anyone necessarily believes on the committee that move-in specials qualified as an excessive rent increase, or that even it's unfair. So I think if members of the committee believe that move-in specials are not predatory and they are separate from these other types of ongoing concessions that we're talking about, and if they believe that the average Mountain View voter might agree that move-in, what you believe about move-in specials, then we did hear from legal staff in the question period when I asked about whether there might be other options that there might be a carve out. There might be potential for a carve out to treat that differently. And whether that's saying, landlords, if at 12 months, if you had a 1 month concession, you can't raise the rent. You have to wait until 30 or 60 days after that. If that's a viable option, it seems like it behooves us, particularly if we believe that it's potentially within the intent of the CSFRA to explore that option. So I'd recommend asking legal staff to, explore that carve out for 30 to 60 day move-in specials specifically, with whatever options we might have. That would be my ask. And if that's if the members of the committee, if you do believe those kind of specials were run in good faith to really help with the specific instance where a tenant, hasn't gotten their deposit back from their prior, unit that they were occupying, and it makes the process smoother. It's really hard, I think, from my personal experience, to look for another apartment when you're trying to schedule movers, get out of your old lease, get your deposit back. I think coordinating all of that is difficult. I think the move-in specials do really help with that. So I would like it to stay on the table as an option. And again, if the committee agrees, I'd encourage us to explore any options that may be at our disposal. Thank you.
Thank you, Committee Member Greenwald, and thank you for staying on during your conflict. We do appreciate you doing that.
No problem.
And next we have Committee Member Rosas.
Good evening, everybody. I am also open to committee members' proposal, Ramos' proposal to soften the blow to landlords, because I do believe that the mom and pop landlords may have been confused on the language of the CSFRA, thus the clarification we're doing tonight. But I am skeptical in regards to the CAA that they didn't understand the CSFRA clearly, or that they didn't do this in well, I'm not going to say that, but I'm going to say that I am a little bit concerned on how the CAA lawyers didn't clarify to their landlords how the law was written, because it is sad that a law that was created by the voters in Mountain View, and it took a lot of work, and it was very, very hard, and they have fought many other attempts of doing away with the CSFRA, that they didn't tell the landlords about this language. So for that reason, I am definitely open to being fair and soften the blow to everyone, because even though I do believe that the landlords who are represented by the CAA have very powerful lawyers, as I said before, and I question that they didn't know about this. Thank you.
Thank you, Committee Member Rosa. I do want to say regarding my own views before we maybe possibly get some sort of discussion around possibly bringing a motion of some nature up here. I tend to agree with the idea of softening the impact. Candidly, I haven't signed a lease with concessions in it since I moved to California, but if I had, I will say that candidly, I would have fully expected that the concession was basically a bonus. It was a non-monetary compensation in exchange for the fact that I was filling the unit possibly quicker, or filling the unit at all. I was getting some monetary benefit in terms of a reduction. I would never personally have thought that that meant my rent went down the next year. I would have never thought, hey, I take that concession month, put it in at 0, add up the other 11, divide by 12, and that gets me my rent. That just would not have been my thought. And I consider myself rather savvy with reading contracts in a detail-oriented fashion, and I would never have interpreted it that way. That being said, I do think that, you know, the plain language argument holds water in that the reality is the words in the definition of base rent are what they are. So unless we truly do believe that a 1 month free or 2 month free is indeed a non-monetary compensation, which I think there is potentially an argument for, you know, I'm not sure if we can or can't treat it differently. If we do treat the 1 month differently, or 1 to 2 months differently, I think we need to acknowledge that there's a non-monetary compensation there. That would then allow us, I think, to rely on the definition of rent as our basis for doing so. Now, the 20% off thing, or 25% off, or whatever that is, month over month, that to me, I mean, that just seems like it's definitely a skirting of the law. So I would want us to take some action to put a stop to that. I do think that that is probably a less common, hopefully a less common business practice. But if it is happening at all, it bothers me that it's happening at all. In terms of the statute of limitations, I don't know if we would, I guess my perspective would be, if we're going to treat the 1 month free or the 2 month free as akin to giving you a gift card, which would be, you could argue, non-monetary compensation upon move-in, or giving you, you know, a laundry card or something of that nature when you move in. If we're going to say it's non-monetary compensation, then I'm not sure we need a statute of limitations if we're really only going to address the 20% off or the 25% off month over month, because I think then we may be creating policy, to committee member Parviza's point of view here, by saying, well, there's a statute of limitations. We may have a better argument by saying that the 1 to 2 month move-in special, whatever the case may be, however we want to subdivide that, is really non-monetary compensation. And your rent is comprised of non-monetary compensation in the definition, ergo, that gets calculated in as a full month periodic payment that's forgiven out of the goodwill of you moving in. I could see an argument there potentially. I think Karen would need to flush it out for us to make sure it works. But I do think that if we're going to say, let's do something about the 25% off, or whatever, the 10% off, whatever the case may be, the month over month discount, that we probably need to think about going stricter to the language and not softening the blow there as we're putting it, really just taking that one at face value. I think it would impact less of a population of landlords, so it may not have as wide-reaching impact on business practice. And I also think that you could probably get into a discussion about move-in specials probably were given in good faith. I do think that mom and pop landlords and many other landlords probably did not think, oh, I'm skirting the law by doing move-in special. I think someone who says your rent's $3,000, but you really only have to pay me $2,500 every month knows exactly what they're doing, and candidly is offering that lease to someone that they believe is not sophisticated enough to figure out what they're doing. So they are taking advantage of someone else, and that's the definition of bad faith. So that's my thoughts. I see committee member Allman has some comments. I'd like to let her speak now.
Given the lateness of the hour, I'm going to be brief. I happen to think that both of the staff reports that were created were really quite elegant in explaining exactly what CSFRA covers, and that as I see it, I don't know, maybe we opened a big can of worms by trying to clarify, but it seems to me that the actual rent paid in the initial period is what we're talking about. And I don't think we have to get too complicated. I mean, I would love to just go at this point to a straw vote and see where we come out. At this point, I really don't know. And I understand that there seems to be a drift toward softening the blow, or whatever you want to call it, or doing something delicate with this 1 or 2 month concession period to offset the bad will that seems to have provided to landlords. Personally, I'm okay with leaving things the way they are. Base rent is base rent. That's all I have to say.
Thank you, Committee Member Allman. Committee Member Allman, before you mute yourself, what would your straw poll be?
I guess it would be to see whether, I think there were 4 points that were suggested by the staff, and I think we could go through those 4 points and see where we end up.
Okay. Does the committee want to bring that up and see where we might
interject? If the proposal is to see if there's a majority to approve the staff recommendation, then I think the way to do that is for a motion and a second and a vote. And if it fails, it fails. If there isn't a second, then it fails.
Okay.
I would be willing to make such a motion.
Okay, so we have a motion on the table to adopt the draft regulations as written, to amend the CSFRA regulations chapter 2 and 4 and Mhrso regulations 2 and 5 to classify the clarification of base rent, et cetera, et cetera. Do we have a second? Don't have the Jeopardy music.
Aren't you actually supposed to say the entire law? I'm not entirely sure.
I think the summary is sufficient.
I'm not seeing a second on that. Am I missing my second? There we go. Vice Chair Reynolds.
I will second. I am open to a discussion, but I will second.
Well, should we call a vote? Because we have a second.
That's what you have to do.
Mm-hmm.
Committee Member Pardo de Zella.
No.
Committee Member Allman.
Yes.
Committee Member Rosas.
Yes, with mini amendment, Committee Member Ramos made.
I don't think there's an amendment on the floor right now.
No, there's no amendment. This would just be exactly as the staff report.
Okay, well then, we're talking about how can we mitigate the effects to the landlords.
I think the options are to vote yes or no, and give staff direction depending on how that vote goes, if you want subsequent work.
Okay, so then I'll say yes.
Vice Chair Ramos.
I'll say yes.
Chair Haynes Livesay.
No.
Motion passes 3 votes to 2.
Okay, so moving right along, we will now move on to agenda item 10.1, the monthly status reports April and May 2022. We will begin with a presentation from staff.
Good evening, committee members. Item 10.1 is the monthly status reports. And we have a series of 3 monthly status reports today, as we did not review April during last month's committee meeting. I'm going to keep April short because we will be reviewing May's, and May will give you the updated numbers. So I do want to point out some highlights here. The biggest highlight is that we continue to see a decline in the number of failure to pay rent notices that are going to tenants. We are also seeing a decline in the vacancy rates and an increase in the average market rent. So the market is recovering and has recovered to almost pre-pandemic levels, which we will highlight in the next month's report. So here we go with the termination notice data. You can see it here. Again, we've had a significant decline if you do the numbers quarterly. And then we also have a decline in the vacancy rates and an increase in the rental rates for all types of units. We also see very little movement in the market for sales of buildings and for the numbers of properties that are being transacted at this time. Does anyone have any questions? Committee members, are there any questions about the April data? Okay, with no questions seen, moving right along, we'll go into May. So for May, we have the most current numbers of 3,812 public inquiries made. The majority of those tenants, and the majority of that is related to COVID-19 rent relief. We have provided 58% of our services in Spanish as a primary language for the recipient. And you can also see that we are receiving a lot of questions about allowed rent increases, as well as property registrations and habitability concerns. So I do want to highlight those numbers. As we've talked a lot about COVID rent relief, we'll start transitioning back into our non-rent relief items, and that is important to note. For the targeted letters that go out every month, we've sent out 875 targeted letters. These are in response to eviction follow-ups. And we've increased our email subscribers to 916. So more people are receiving our information and are interested in finding out about the services that we offer. For mediations, we've seen a slight increase. We have 132 mediations at this time for a total of 113 that have been resolved, with 18 pending. This month, we received in total for the past 2 months, so through May, again, 138 eviction notices for failure to pay rent were received by tenants. That's substantially lower than last quarter. We have had a few more petitions come in. A few of those petitions have since dropped off as people were able to conciliate with their tenant and their landlord based on the work that staff did during the petition process. So that is good news. You will see these numbers change next month. There will be fewer items in review and more items in the settled category. And here we go for vacancy rate data. So you're going to see here some changes in the market that are significant. We have once again gone into the 4.7% below. We are below the threshold for the CSFRA. We are back below 5% in the market. So we have recovered officially, I would say, in terms of being below our threshold. In terms of a healthy housing market, that's debatable, because if you're below 5%, technically it's not a healthy housing market, which is why this law is in effect at this point. You will also see in the newly built units a spike in units that are vacant, and that's because we had 2 new buildings come online. So this data for newly built units is almost always a little bit inconsistent, and it's because when new buildings come online, those vacancy rates are included in that data. There were about 200 units that came online this quarter, and that's what you're seeing there. We have a vacancy rate for partially covered units of 2.2%. And again, the all units data is now skewed because those newly built units were included in this data. So you're always going to see those changes in those 2 numbers. For the average market rent, you'll see that we have recovered in that as well. The average market rent is almost back to what it was fully pre-pandemic. And we're at $2,688 being asked on the market for fully covered units. And for partially covered units, we're at over $4,000 per unit at this time. And no change in the properties for sale here information. Again, properties are not transacting in large numbers at this time, and we're not seeing a lot of, well, we're actually seeing no redevelopment at this time, and we haven't for the past few years, most likely due to SB 330, the state law. So that concludes the monthly status report for May. Does any committee member have any questions that they'd like to ask staff?
Any questions, committee? Oh, committee member Rosa.
No, well, I didn't have a question. I had more of a comment. Is that okay? Well, this is just questions.
We'll go into deliberations and feedback after public comment.
Sounds good. Oh, sorry.
And for the eviction prevention program monthly status report, we have held 2 additional clinics. We've assisted 810 total clients since August, and 343 clients, individual tenant households, applied for state rent relief through our city's eviction help center. 85% speak a primary language other than English, with 82% speaking Spanish. And again, this data has not changed, but I do want to just highlight that we are truly helping the people who are in need of the assistance the most in our community, with 71% of households having 3 or more people in the household, and the majority of those households live on $25,000 or less for the entire household. We have 48% of attendees having applied for the city's rent relief program, and they received an average of 2.3 months of assistance from the city. We have 27% who received termination notices, and they are on average 2.4 months behind on rent, and 165 clients have requested and received legal assistance pro bono through the program. And so we're going to go into these numbers quickly. We've received 2,959 public inquiries, with tenants being the bulk of those. We've held 14 eviction help center pop-up events, including one on June 11th. That's not in this data, but we'll talk about it later. I just want to mention it. We had a great event in June, and Andrea will share more about that. We've held 24 webinars. We reached 156 community members. We've had 3 postcards that have gone out. We'll likely be sending one out at the direction of the city manager's office at the end of June, the beginning of July, as the last round of eviction protections expire. Working on language for that as well. And then we have the bulk of the websites and pages that we maintain still being maintained. We're starting to transition over from rent relief related focus to a more broad housing and eviction help center focus in the next few months. And here you'll see the most updated state numbers for the state rent relief. They've had 781 complete household applications for a total of 677 households that have so far been served. That means that they have about 100 households left that they have not served and are going through those final applications, for an average assistance of $11,000 per household and a total funding of $7,461,000 for the city of Mountain View specifically. And that concludes staff presentation. I will take questions at this time if there are any.
Any questions from the committee? Okay. No questions? Okay, seeing no questions, I now invite public comment. Would any member of the public on the line like to provide comment on the monthly staff report items? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. And I see one comment. Sky, would you like to comment? Oh, now I see two.
Hi, thank you. Thank you for going over all of that, Patricia. That's always very interesting and helpful. I know the ordinance already, or the proposal already passed. I want to just point out to everyone that it just seems bizarre to me to piecemeal it. If you want to provide the 1 month free as a potential carve out, I would highly suggest waiting on, approving the proposal until you approve it in its totality. This is very stressful for landlords and tenants and just creates confusion. If the goal is clarity, then wait until you can do the whole thing in its totality. I will tell you, people are looking to start selling their businesses, and people are looking to see how they can convert these apartments into something else. The process also, the law that you stated, is not telling us how this would be invoked inside of the petition process, and the petition process is not easy. We are currently working on it because our income is 50% of what it was in 2017 or whatever the base year was. So landlords truly are suffering, and approving this policy without that carve out that both hurts tenants and landlords. It's just, you're gonna have less housing for people ultimately, and people are trying to flee Mountain View as quickly as they can. This is so harmful, and the way it's being done in a piecemeal fashion is harmful to the tenants because they're confused. It's harmful to the landlords because they're confused. And that's all I have to say. I just hope you guys will consider at least waiting to make that full decision, so there's not a back and forth and there's not confusion between the landlords and tenants, and we can all move forward in our lives in an orderly way. So thank you.
Thank you, Sky. And Karen, would it be appropriate for me to address that the item did pass as written?
Yes, so I think the action's already been taken.
Yes, action was taken. The item passed as written in the staff report. I don't believe there's any carve out in there.
That's correct.
Okay, very good. And again, we are doing comments on the staff reports this time. Edie, do you have a comment on the staff reports?
Thank you. I do have a comment on the staff report. I would like to thank the Rental Housing Committee for being patient during the pandemic and having faith that the rental housing market would return to a much more normal situation, including a vacancy rate that is under 5%. So it's very reassuring to see that return has happened, and I appreciate your restraint to not consider a survey and returning the rental house, or the potentially turning off rent control. And also, the related item here seems to be the registry. So it would really be good to know about apartment by apartment where there are apartments that are vacant and what rents are doing. So that'll be valuable information to everyone. Thank you.
Thank you, Edie. Any other comments? Okay, seeing none, we will now go into committee deliberations and provide feedback. I know committee member Rosas wants to provide some feedback.
Well, I just wanted to say that I'm really happy to see that the emails, that people from the community are actually wanting to know what's going on in the city and what services that can help them. That is definitely very, very good as a committee to see that that our community is getting engaged in the process. Oh, so I want to thank, I want to thank the staff for such a great job that they do every day, and how well prepared they are for every RHC meeting.
Thank you, Committee Member Mhrso. Does anyone else have any feedback on the reports? No. Very good. All right, we will now move to agenda item 10.2, CSFRA fiscal year 2022-23 budget and annual rental housing fee. We will begin with a presentation from staff.
Thank you very much, Chair and Rental Housing Committee members. Today, we're going to continue the agenda item from last month by recommending to adopt the fiscal year 2022 and 23 recommended budget and set the rental housing fee for this coming fiscal year. Just to remember, the section 1709D and J of the CSFRA empower the Rental Housing Committee to establish the budget for a reasonable and necessary implementation of the provisions of the CSFRA to finance its reasonable and necessary expenses and charge the annual rental housing fee. As mentioned in last month's meeting on May 23rd, you reviewed the draft budget and agreed with the recommended budget for 22-23 and the annual rental housing fees. As a short summary of this last discussion, the total budget would end up to be $2,078,007, with personnel coming to $1,058,647, the general operating cost $173,500, the professional services to $416,500, IT system and maintenance $133,000, and city resources and administrative support and $296,360. As also was shared in the last month's meeting, adopting this budget would result in a fee of $96 per unit. The number of fully and partially covered units has not changed since last year. It's still at 14,950. So the recommendation for today would be to adopt a resolution to adopt the fiscal year 2022-23 budget and establish the rental housing fee sufficient to support this budget for 22-23. Any questions? Happy to answer.
Committee, do you have any questions? Okay, seeing none, I will now invite public comment. Would any member of the public on the line like to provide comment on this item? This is the budget and housing fee item. If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. And I see Teresa. Can we advance Teresa to a speaking role?
Hi, everyone. I guess I'm still reeling from the adoption of the resolution at the urging of Karen Tiedemann. But I would like to address the budget, which is the issue here. I did send Anki an email about very specific questions related to the IT budget and issues with the registry that have not been addressed. It is a significant budget. I would like to see a response to that. I think we're entitled to that. So I'd like to hear from staff when we could expect an actual specific response to the specific questions raised. And I would like to comment, the budget is just huge. It's over $2 million. This is becoming, really a bureaucracy that's sort of feeding itself. Anyway, those are my comments. Thank you.
Thank you, Teresa. Anki, did you want to say something? I saw you on mute.
I wanted to say that we did provide an answer saying that we would recontact 3DI, which is our provider for the registry, with the specific questions and requests that Teresa has made. So we are in the process of working on that.
Excellent. Thank you. Okay, next I see Alex B.
Hey, Al. Just want to say, Anki, Andrea, Patricia, Jessica, Karen, Nazanin, wherever she is, you're worth every penny.
Thank you. And next I have Jeff.
That's funny, Alex, you say that, because you know what? They're regulating landlords using landlord money. It doesn't cost you a dime. So you ought to be doubly proud that you're stiffing landlords to protect your crazy ass rent control. Teresa does deserve an answer and deserves it instantly, or not instantly, but earnestly, and it shouldn't be dismissed. Like I said, we're paying for this budget to get regulated by you guys, and we get punished every time. So these rates should be lower than they should, and we shouldn't be getting discounts. We took a loss. We take a loss every time you guys come to a meeting. Every time we come to a meeting, we take a loss. These rates should be finding a way to come down, and come down significantly, and stop screwing us every time. Screwing us every single time.
Thank you, Jeff. And now we have Edie.
Thank you. I would just like to point out there is a tenant's point of view regarding the annual housing fee. And it's that there's vacancy decontrol. And so, well, you know, all the landlords are business people. They are certainly considering what the annual fee is when they are setting the rents that they are charging for new tenancies. Thank you.
Thank you, Edie. Do I have any other commenters? Okay, seeing none, I'm bringing this back to the committee. Now, committee, we can have deliberation, we can have discussion, but a motion to approve should include reading the following: to adopt a resolution of the Rental Housing Committee of Mountain View adopting the fiscal year 2022-23 budget and establishing a rental housing fee sufficient to support the fiscal year 2022-23 budget. Do I have comments or a motion? I see Committee Member Allman.
I'd like to make a motion to adopt a resolution of the Rental Housing Committee of Mountain View adopting the fiscal year 2022 to 2023 budget and establishing a rental housing fee sufficient to support the fiscal year 2022 to 23 budget, to be read in title only, further reading waived.
Excellent. And Vice Chair Ramos, do you have a second?
I will second that.
Excellent. Let's call the vote.
Committee Member Pardo Drizella.
I don't think we got your vote. I'm sorry.
I'm sorry, abstain.
Committee Member Almond.
Aye.
Committee Member Rosas.
Aye.
Committee Vice Chair Ramos.
Aye.
Chair Haynes Luce.
Aye. I think that motion passes.
Yes, motion passes. 4 votes yes and 1 abstention.
Excellent. We will now move on to agenda item 10.3, contract with Project Sentinel for fiscal year 2022-23. We will begin with a presentation from staff.
Thank you again, Chair, members of the Rental Housing Committee. As we do each year, after we approve the budget, we have to authorize and ask authorization from the Rental Housing Committee to sign any contract over the amount of $50,000. So for this agenda item, we would like to request the Rental Housing Committee to authorize the program manager or other designee to execute an agreement with Project Sentinel for the administrative and hearing process services for the next fiscal year in an amount not to exceed $115,000. As background information, Project Sentinel has provided administrative and hearing process services since fiscal year 17-18, and following an RFP process in November of 2018, the Rental Housing Committee selected Project Sentinel to continue to provide these services for the CSFRA. So for this coming fiscal year, the services from Project Sentinel are estimated not to exceed $115,000, $10,000 for administrative support, $5,000 for pre-hearing facilitations, and $100,000 for hearing officer services. And as mentioned, it is brought to you today since any policies and procedures authorization is required from the Rental Housing Committee over $50,000. So the recommendation is as follows. To authorize the program manager to execute an agreement for Project Sentinel in an amount not to exceed $115,000 as indicated. Happy to answer any questions.
Does anyone have any questions? Okay, seeing none, I now invite public comments. Would any member of the public on the line like to provide comment on the Project Sentinel contract item? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Okay. I am seeing no public comment. Next, we'll go into committee deliberations and provide feedback, possibly also a motion to approve, which would include reading the following items as appearing on the screen. Do I have comments? Oh, there we go. Vice Chair Reynolds.
I'm going to make the motion. I move to authorize the program manager or other designee to execute an agreement with Project Sentinel for administrative services relating to the CSFRA for fiscal year 2022 to 2023 in an amount not to exceed $115,000 as follows. A, administrative supportive services, $10,000, facilitators, $5,000, hearing officers, $100,000.
And committee member Rollback, do you have a second?
I will second.
Excellent. And now we can call the vote.
Committee member Pardo Dizella.
Aye.
Committee member Alman.
Aye.
Committee member Rosas.
Aye.
Vice Chair Ramos.
Aye.
Chair Haynes Lipsett.
Aye.
Motion passes unanimously.
Excellent. We will now move to agenda item 10.4, contract with Goldfarb and Lippman LLP for fiscal year 2022-23. We will begin with a presentation from staff.
Thank you again. Equally to what we just discussed with Project Sentinel, this contract is over $50,000 and therefore requires the authorization of the Rental Housing Committee. So we would like to ask an authorization to the program manager or other designee to execute an agreement with Goldfarb and Lippman for legal services related to the CSFRA for fiscal year 22-23 in an amount not to exceed $175,000 and to represent the Rental Housing Committee and or the City of Mountain View in pending litigation related to the CSFRA for the next fiscal year in an amount not to exceed $100,000. As background, Goldfarb and Lippman did provide services for the CSFRA since its inception in 2017-18 and following an RFP process in November of 2018, the Rental Housing Committee selected Goldfarb and Lippman to continue to provide these legal services for the CSFRA, and it also retained Goldfarb and Lippman to represent the Rental Housing Committee in litigation related to the CSFRA. So the services for 2022-23 for legal services is estimated not to exceed $175,000, and for litigations services is estimated to not exceed $100,000. And we are requesting authorization of the Rental Housing Committee since this is over $50,000. Again, the recommendation is as follows: to authorize the program manager or other designee to execute this agreement as mentioned with Goldfarb and Lippman. Any questions? Happy to answer.
Committee, does anybody have any questions on this item? Okie dokie. Seeing none, I now invite public comment. Would any member of the public on the line like to provide comment on this item, which is the Goldfarb and Lippman contract? If so, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Okay, seeing none, I'm going to bring it back to the committee for deliberation and possibly a motion. Remember, a motion to approve should include reading the following items as appearing on your screen today.
I'll make a motion to authorize the program manager or other designee to execute an agreement with Goldfarb and Lippman for legal services related to the CSFRA for fiscal year 2022 to 23 in an amount not to exceed $175,000, and to represent the Rental Housing Committee in the City of Mountain View in pending litigation related to the CSFRA for fiscal year 2022 to 23 in an amount not to exceed $100,000.
Excellent. And I see Vice Chair Ramos has her hand up. Do you have a second?
I will second that.
Excellent. And can we call the vote?
Committee member Pardo de Zella.
Abstain.
Committee member Alman.
Aye.
Committee member Rosas.
Aye.
Vice Chair Ramos.
Aye.
Chair Hain-Livesey.
Aye.
Motion passes 4 votes with 1 abstention.
Excellent.
4 votes
well,
yes. Sorry.
No problem. No problem. Thank you, committee members and staff. I think we will now move on to committee and staff announcements and updates. I will hand it back to staff for some presentations.
All right, there we go. Can you hear me? No echo?
You're good.
Okay, perfect. All right, so let's go over the workshops, clinics, and office hours. So of course, we are still continuing with our Housing and Eviction Help Center. That is both in person and virtually. And it's the first and third Thursdays of each month at the Mountain View Public Library from 1 p.m. to 5 p.m. If anybody's interested in joining virtually, they can go to mountainview.gov/eviction help clinics. And so at the Help Center, we're covering housing programs where people can learn about our rent stabilization laws, apply for affordable housing, connect with different rental assistance programs, and we're still helping people check the statuses of their California COVID rent relief applications. We also have eviction help, where we can answer questions about people receiving, or if landlords come and they're serving termination notices, we can answer questions about that. We also have legal resources and lawyer referrals that we do at the Help Center. And we have other types of supportive services where people can get assistance with food distribution, financial assistance, our mediation program, and homelessness prevention services. And as far as our upcoming webinars or workshops go, we have one tomorrow at 3 o'clock for our landlords, when we're going over sort of landlords' rights and responsibilities. And then we have another tenant-focused webinar where we go over tenants' rights on Wednesday at 6:30 p.m. And this will be bilingual English and Spanish. And next month, Tuesday, July 19th at 3 o'clock, we have a landlord-focused webinar on rent and rent increases. And then, of course, on the next day on Wednesday, we have a tenant-focused bilingual English and Spanish webinar at 6:30 p.m. And then I did also want to talk about our event that we had on June 11th. So we had our community kickoff event Saturday, June 11th from 10 a.m. to 1 p.m. This was at Rangsdorf Park. And you can see some pictures here. I got some organizations. We have our program at the top left, Catholic Charities, Chalk, who was our co-host. At the bottom, we had story time from the Mountain View Public Library. And then the bottom right here is a picture of the raffle where we had Mayor Ramirez actually come and pick the raffle tickets. So that was very nice. At this event, we had what we calculated as about 210 community members go through. And we know this because we had each attendee pick up what we called a passport, where they could actually get a stamp at each table that they went to for each organization. So it encouraged people to really visit each table and get information from each organization. And if they did complete their passport, they got a raffle ticket. So that was a big hit. And of course, I did want to take just a minute or two to acknowledge and thank our local organizations who took time out to participate in the event and connect with our community. So we did have our co-host, who was Chalk Family Resource Center. We had with the housing department, the Mountain View Housing Department. So they talked about affordable housing and sort of our BMR part of the city. We also had Project Sentinel with us, Catholic Charities, the Day Worker Center. We had CLESPA, the County of Santa Clara was there. We had CSA and the City of Mountain View Library. So they had a table and they also did our story time. There are also some fun activities, of course, including the story time, which was a huge hit. And then we had some other local people come in and do some things with the kids. So we had an art class by a local artist. I believe it's pronounced Giada Conte. So she did a nice table with all of our sort of young children where they could color and do some art and some crafts. We also had shaved ice that was, yes, and it was hot, so it was very, very much needed. So we had some shaved ice that was provided by our community member, actually the father of one of our rent stabilization staff, Alitzel. So he was there and provided much needed relief from the heat. And then every table had a craft that they put on. So that was a lot of fun. I think it was a huge success and just really a great way to kick off the summer with our community partners, and most of which are actually participating with us at the Housing and Eviction Help Center. We have a partner day on the first Thursday of each month, and most of these organizations are there and represented and providing information and services to the community. Any questions about that?
Any questions from the committee? Okay. Seeing none, are there any additional comments or announcements from the committee members or city staff? Vice Chair Ramos.
Oh, I'm so sorry, staff. You're just going to hate me for this. Fair warning, fair warning. Back to the agenda item that we had earlier this evening. I am interested in legal staff exploring options that would still comply with the CSFRA. And so
but figure out a way to deal with the 1 month free rent. And I am not equipped nor capable of figuring that out, how to shoehorn that into the CSFRA. When it came down to it, it actually was, the committee member Paradizel's comments really made me think. It was just, we aren't building policy, we are clarifying the CSFRA. And it is the first priority of our committee to uphold that. But I don't know how we can. I don't have any resources or options. I'm unaware of any options to find ways to enable that first month free rent issue. I don't even know if that was the right way to ask it. And I don't even know if that's coherent at 10:30 p.m. But it does. I guess that's just the basic.
So summarizing is, we did adopt a resolution, but I think you had an ask about how it would even be an option to weave in the 1 month free rent as an exemption to the factoring in the concessions and base rent. Is that what you're saying?
Yes. I'm not prepared to shoehorn language in that yet, and without seeing the full consequences of that. But I just wanted to see those options, explore that option. I don't know if that makes sense. And I know that this equals so much more work for staff, and I'm really sorry.
Karen, how do we need to treat this?
So this is a little bit out of the ordinary, and there isn't really anything in your guidelines about this. We have passed that item on the agenda, but I think if it's okay with the rest of the RHC, we could go back. You could give direction to staff to explore that issue and come back with further amendments or a report on why we don't think we can do it if that's the case.
And I would prefer it being absolutely narrowly scoped to the issue of the 1 month free. I actually want to make sure that we have everything else in place. If that makes any sense.
Clarify briefly. I guess I'm a little confused because we passed a resolution that covers that. So are you this to say that you want to redo the vote on that one item? Because we passed a resolution that includes language that specifically addresses this. And so I'm not real clear on what the ask here is, because the question's been answered. It was asked and answered, and it went through too. All right, committee member Paradizel.
Yeah, I mean, I would move that we stay implementation of the reg that we just voted on for 90 days. So it gives us 90 days breathing room before it's implemented. And if we want to tinker with it or make it better or worse during that period of time, we've got at least 90 days to think about it, rather than just going full on in, and perhaps some of us have some reservations about it. So that would be my motion. I would move, if I may, to stay for a period of 90 days application of the resolution of all of the regulations that we passed in the, someone's gonna have to tell me the agenda item, but the agenda item that was covered earlier.
Can we do that, Karen, and take a vote for that, since we're now under item 11?
Well, I think, this is an item that is on the agenda. We have passed the item, but You know, I think if the chair wants us to come back to the item, you know, given that it was on the agenda already, it is a little bit out of the ordinary, and I would note that most of the public has left. So there isn't really an opportunity to get a lot of public comment. So, you know, I think it's a little difficult. I'm trying to give you as much latitude as I can, but it's not clear.
To be clear, I am not asking for a motion to reconsider a vote. And I do, from what I remember, at least in council policies, only people who voted, who sent on the winning side can motion to reconsider the vote. I'm not asking for that. What I'm asking is for something much more narrowly scoped. I felt that it was more important to make sure that we had some clarity in place for the issues that we knew were issues. I wish I was much more coherent, but that's why I couldn't figure out a way to amend the motion there.
I really think we need to proceed. We already took the vote. The people who, you know, made public comment are primarily gone. We can't start over. I feel really strongly about this.
I mean, the only way I could see doing this is, Vice Chair Ramos, are you saying that your second was done in error, and you're saying that you would not have seconded the motion as indicated at that time if you had understood what you were seconding? Because you seconded the motion. So to change it, I
want to be clear. I don't think, I think even if Vice Chair Ramos said she made it an error, that doesn't undo the vote.
Right.
The only option is a motion for reconsideration. And one of the 3 RHC members who voted in favor has to make that motion, and it has to happen at this meeting. So, but what I think I'm hearing Chair Ramos say is she would like staff to think about it and potentially come back with amendments to the regulation that could address that issue.
If
so would that come back in the July meeting? Because this is now live.
That would be up to the RHC. You have a special meeting in July for a appeal hearing. You could add to that agenda.
Okay, and committee member Partidizella, you wanted to.
Yeah, I mean, my question for council, as things are right now, when would the regulations be effective that we voted on tonight? Are they effective as of today, or is it 30 days, or when are they effective?
Your resolutions are effective immediately.
Okay. So just on that point, I mean, whether I can make the motion or not, I'm going to suggest that someone else make the motion then, but I think that it would be appropriate not to change the regs at all. I don't think I'm suggesting that, but to simply say what we voted on, that we want to stay implementation for a period of time, whether it's 60 or 90 days, to make sure that we can take a deep breath, and it's 10:30 at night, and at least sleep on it. And and my intention would be, if no one does anything, if we follow this course, then it does go automatically into effect in 60 or 90 days. So it would still happen. It's just that it gives us some time to, you know, think this. It's like a waiting period to make sure that you got it right. That's all I would suggest that someone make a motion on.
I will say right now, I'm not comfortable with staying the regulations. I want options. I think that's really all I'm kind of asking is options, because there is just a bit unsettledness. And I know it's frustrating. I probably opened a lot of chaos, and I'm very sorry about that.
This has been under discussion since March, so it's no brand new item. I don't see any point in if we put a stay, then we're going to get 3 months more of public comment, And, you know, brouhaha, I think it's time to settle things and for people to get used to the base rent as it has been written. Can we adjourn the meeting? I'm really tired. I'm sorry, guys.
We do still need to let legal counsel report on the closed session. So if I don't have a motion to do something about 9.1, whatever that may be, from one of the three people that voted yes, I am going to move on to having legal counsel report updates from the closed session.
Okay, yes. Before this meeting, the RHC met in closed session to discuss a matter of pending litigation, Redwood Villa versus the City of Mountain View and the Mountain View Rental Housing Committee. No action was taken on that item.
Thank you. Okay, if that's it and I have nothing else, the meeting is adjourned at 10:42 p.m. The next Rental Housing Committee meeting is scheduled to be held on Monday, July 18th, 2022 at 7 p.m. Thank you, and everyone have a wonderful night.